When I joined the Commission in August 2021, 2 months later, the complaint in relation to the PCR test case was made in October, and I was brought into the case at the end of November 2021. The PCR test case related to the price charged by private pathology firms to conduct PCR tests, which is the gold standard for COVID testing. The Omicron virus had just been discovered in South Africa, so quite a lot of people had to perform COVID tests. At the time the complaint was made, it cost 850 rands per person per test. So the complaint received from the Council of Medical Schemes was that the price of 850 was excessive when regard is had to the cost of conducting the test. So our brief was to investigate whether a price of 850 was excessive and to come up with a remedy that is either referring the case to the tribunal for prosecution for excessive pricing, or to try and find a settlement with the private pathology firms. My role in the case was just to do a deep dive into the numbers provided to the Commission by the pathology firms. That is, to understand the revenues that they made, the costs to the labs of conducting a PCR test, to do a reasonable analysis between the price charged of 850 and the costs incurred. And also what we had to do was just to do a comparison of the various cost items for the pathology firms to compare against each other. After we had established that the cost of 850 appeared to be excessive, we had to do a calculation of a minimum price that the pathology firms could charge for a PCR test and still remain profitable. The outcome of the settlement between the Commission and the pathology labs, just in simple numbers, was a reduction in the price from 850 to 500 rands. But just at a personal level, a week after the settlement was signed between the Commission and the pathology labs for the decrease in price, I myself had to undergo a COVID PCR test, and it cost me 500 rands. And had I gone for the same test just a week earlier, I would have paid 350 rands more. It is also important just to note that at the time, if anyone wanted to do international travel, they would be compelled to present a negative PCR test result. Also, at the time, if you wanted to be admitted to hospital for any procedure, you are compelled to do a PCR test to determine which ward you would be admitted to in hospital. So the reduction of the test price from 850 rands to 500 would have had quite a telling impact on society.
Well, consumers are complaining about a surge in prices for essential foods. The looting spree in South Africa has led to many people panic buying, worried that essentials such as bread and fuel will run out.
Following the onset of the COVID-19 pandemic, and the state of disaster in March 2020, there were media reports and complaints around price increases for essential food products after we saw some panic buying by consumers. Considering the importance of food, the Commission immediately started monitoring the food markets to check on the prices. The need to look into food markets also followed from low-income households bearing the brunt of the resulting economic crisis, with essential food items making up a significant portion of expenditure in poorer households. The Commission's main findings from looking into the food markets include, firstly, the abnormal food price inflation we saw at the start of the lockdown resulted from the rand depreciation at the time and initial panic buying, which we saw disrupted normal demand patterns. Secondly, during this time, the price monitoring showed that retailers benefited the most, as we saw increases in the wholesale to retail price spreads, and the financial performance reflected higher overall profitability, mainly at the retail level. Another finding was that in July 2021, the riots and food supply chain disruptions in South Africa showed that the more longer industrialized food chains are then more exposed to volatility. This then raises the potential need for some reform to the industrial market structure if we are to achieve more sustainable and inclusive agriculture. Another finding, our food research also showed that the global trend of the increasingly traded nature of food is also seen in South Africa, as we see the trade of food products increasing in terms of both import and export value. Finally, another finding from the report is that as global food inflation remains a concern, the latest monitoring report shows from August this year, it highlights the main drivers of food inflation, being aspects that are interlinked, such as the Eastern European conflict and its effect on global wheat and maize supply, rising fertilizer prices, surging energy prices, and the current high levels of concentration we're seeing in value chains, as well as the asymmetric transmission of food prices, where we generally see that prices are quick to rise but slow to fall. For the Commission, I feel the team's food market research has shown that food prices can often be linked to local or global supply changes, generally from adverse weather events. Another aspect to monitor for the team is the impact of volatility in South Africa's food markets, especially on poorer consumers. The latest food price monitoring report highlights that price increases in imported products should not be unduly exploited by intermediaries or processors who could impose larger price increases than warranted. Looking ahead, the Commission will also continue to monitor food prices and probe essential food price increases that appear to be abnormal or excessive. The team will also monitor and assess the transmission of cost reductions to the local market, where these are due or anticipated in relation to an easing of global food supply constraints. For consumers, the food research would hopefully empower them to become more aware of significant or abnormal food price increases and report these to the Commission. And hopefully these reports can also assist consumers to better understand the country's food markets.
In a vote of confidence about South Africa's long-term prospects, New York-based food and beverages giants PepsiCo has made an offer to buy Pioneer Food Group, which makes Sasco breads and Ceres juices, in a deal worth over 25 billion rand.
The Competition Amendment Act came into force in July 2019. Barely 2 months later, a Simba Pioneer merger was notified to the Commission. So this was really the first time we had to, as the Commission, consider the implications of the new amendments, particularly to Section 12A3C and Section 12A3E of the Act. So this was really the first time we're looking at this case through the prism of the amended Act, and it turned out to be a seminal case in respect of those amendments. This case provided us with an opportunity to learn a lot about how to give effect to the promotion of a greater spread of ownership. So there was a fund created which ensured that there was skills transferred to youth small businesses and firms owned by HDPs, teaching them farming and other general business skills. There was also funds set aside to ensure that small farmers can access markets. Insofar as workers were concerned, we had to consider how they can meaningfully participate in the economy. And again, here we eventually reached consensus with the parties whereby they set up a certain percentage of the shareholding in the target firm, which was to be held in a workers' trust on behalf of the workers. And this actually equated to a value of 1.6 billion, and dividends would flow to workers from day one. So this set the template for later cases whereby when we involve workers and worker participation, we expect that there must be no encumbrances to that shareholding and dividends must flow from day one. This case really provided a template from which we could take these amendments forward. And there were a lot of learnings. For example, we learned how to craft meaningful employee share ownership schemes that are truly transformative in the sense that they provide workers with board representation. They are unencumbered in the sense that workers can start enjoying the fruit of those dividends from day one. Some questions remain unanswered, such as, in which entity should workers participate in? Should it be an entity that is domiciled in South Africa? Can it be elsewhere? And these will obviously be further crystallized through the development of the jurisprudence. And I think we're looking forward to the conference where maybe some other views can be heard from labor, business, the legal fraternity, as to what their thinking is about how we can give meaning to these amendments.
Just to inform you, we're just waiting for some further commission officials to arrive.
Welcome.
And then we'll start shortly. Thank you for your patience.
Welcome to the Competition Commission. The Competition Commission is an investigative and prosecutorial body set up in terms of the Competition Act of 1998. We have three main functions: to investigate anti-competitive conduct, to evaluate mergers and acquisitions, and finally, to assess exemption applications. We investigate many cases in these areas, but today we'll focus on just a few exciting cases that have had a big impact on the market over the years. For instance, Musi, an analyst in the Mergers and Acquisitions Division, will tell us all about the Cashbuild and Buco merger. Anele Daka, the Commission's first in-house financial expert, will take us behind the scenes of the all-important PCR case that saw COVID testing prices come down. Besides investigations, we'll hear about other market interventions, like the work the Commission has done in the school uniforms industry and the guidelines the Commission facilitated in the automotive aftermarket. So, let me not waste any more time. Over to the analysts.
As mentioned, we're just waiting for a couple of commission officials to arrive. Their bus unfortunately left Pretoria a little bit after they had planned, and there was a bit of traffic, but we should be starting shortly. Thank you for your patience. Oh, are they changing the wheel?
Service providers they can use to repair their motor vehicles, and also for the products that they can buy in the automotive aftermarket. With the implementation of the guidelines, consumers can choose to have their motor vehicles repaired by a service provider of their choice, whether an approved service provider or an independent service provider, such as a panel beater, service centre or approved dealer. They can also choose to fit original or non-original spare parts in their vehicles without voiding their warranty. They can also choose to purchase service plans, maintenance plans and other value-added products at the point of sale when they buy a motor vehicle, or they can choose not to do so. With our engagements with industry stakeholders in the sector, we pay particular attention to introducing measures that would increase participation by small businesses and disadvantaged groups. With the implementation of the guidelines, it can increase more opportunities for small businesses to service, maintain and repair motor vehicles that are covered by a warranty. It also increases their access to original spare parts that are sold by car manufacturers, and also allows them more opportunity to become approved dealers and approved repairers on the panels of car manufacturers and insurance companies, as well as increasing their access to training by car manufacturers and also the technical information that they need in order to repair in warranty vehicles. There is still more work to be done. The Commission is currently monitoring the steps that are being taken by the industry in order to implement the guidelines. We are also engaging with industry bodies and associations that have supported the guidelines and are promoting compliance. And towards the end of the year, we intend to introduce a survey for the industry stakeholders to answer, which will allow us to assess the level of compliance with the guidelines by the industry.
The Commission's advocacy work relating to service provider panels in the banking industry actually began with the engagements between the Commission and the banking sector in 2018 and 2020, where the Commission had identified competition concerns with the bank's conveyancing practices. And those engagements led to the country's largest banks offering undertakings or commitments to revise their practices. And that enabled competition in the procurement of legal services by the banks, and the banks gave undertakings which meant that they would refrain from locking in law firms on their panels and open up opportunities for smaller and HDI law firms. The Commission has recently issued a practice note in February 2022. The practice note sets out key principles for promoting competition and inclusivity in supplier panels of banks and insurers. And this came after the Commission consulted the industry in a closed workshop. With the practice note, the Commission intends to encourage reforms of practices and adoption of key competition principles by banks and insurers, which would ensure that when they appoint service providers for all of their panels, they adhere to these principles. And it's important to note that the banking industry and insurers actually procure these services not only for their consumption, but also on behalf of their customers. So these interventions came about due to complaints received and investigated by the Commission, which first revealed there was a prevalence of exclusionary conveyancing practices in the banking sector. For example, the terms agreed between banks and law firms for conveyancing work prevented law firms from taking on instructions against the banks in instances where they have concluded service level agreements with the banks. But also the Commission had received complaints which had revealed that there are concerns relating to the unfair appointment of work to service providers, and that the allocation of work was actually not fair and inclusive. So from these complaints, the Commission then found that certain aspects of these supplier panels raised competition concerns to the detriment of consumers, and these issues related to long-term exclusive agreements, as well as barriers which prevented the entry and participation of SMEs and companies owned by historically disadvantaged individuals.
Good morning. Mr. Majenge, Are you well today? And not feeling the effects of yesterday? There was so much heartfelt love, outpouring. Hey, Mr. Paladi, advocate Paladi. I see our colleagues coming in from the back. We hope not to start without them. Good morning, good morning, good morning. Good morning, good morning, good morning. Good morning, good morning, good morning. Thank you. Oh, there's an old friend. Hello. I'd invite you all to take your seats. Good morning. Good morning. Hi. Just going to let the love flow over. You know, this is a good problem. It's that we love each other so much. We haven't seen each other for so long. We just can't stop. It's a good problem to have. It's a good problem to have. Advocate Paladi. I know he's getting work, maybe. All right, I'm going to get started. Thank you all for your patience. That's the first thing I'll start with, because I know we haven't started on time this morning. We wanted to make sure that we had as many people from the Commission here as possible, as they are the co-hosts today. For those of you who don't know me, my name is Mpumelelo Chabalala. For the Ngunis in the room, yes, I do have a man's name. That was intentional by my parents. They gender bent us all. And for those who struggle with Mpumelelo, to our Russians in the room, you can call me Mpumi. I'm happy with that. Thank you. Songezo introduced me yesterday, and he was so generous. And he said, everything that he's done, I've done better, which, you know, maybe I have. But what he left out was where we met. He and I met at the Constitutional Court of South Africa, and I arrived, and Songezo was part of the team of clerks who were there receiving the new team of clerks. And in addition to that experience and all the other experiences he mentioned as part of our accolades yesterday, one thing he didn't say is that he went first. He led. And though I may be doing it better, I do it better because I had someone to follow. And similarly today, there's so much symbolism about that. Yesterday, we've got this beautiful symmetry. I think it was planned that way. Yesterday, we had a male MC. And today, you have a woman MC. Yes, yes, yes. Yesterday, you had a male commissioner. Today, you have a woman commissioner. Yes. 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 And following in the theme of symbolism, I'm wearing green for the first of spring. I'm wearing green for new growth, just like I promised Doris. That, you know, it's like a sprout coming from the ground. And in addition, I will just hype up some South African small businesses from which I got my outfits. Please feel free to ask me where I got them so we can advertise those businesses, because that is also so much a part of what we love about what we do here. So Songezo and I go back quite a while, and we've had many disagreements. But what I love about him is we have a sort of brotherly, sisterly, familial love. And what I like is that kind of container means that you can argue and fight with passion and with your principles and with vigor. But you always return back to the mutual respect and the fact that you come from the same roots. The roots of kind of having the same vision and really ultimately the same goal, though we may disagree about how to get there. And it's in keeping with that spirit that I hope the handover happens at the Commission. I'm very different to Songezo. I'm not as stickly about time, but perhaps, we can encourage and think about this transition at the Commission in the same spirit. That we want to encourage a new wave of thought that's not about rejecting the past or hating the past, but rather vigorously engaging with it and saying, this is my stamp on where we're going to go for the future. And we do that because we do that from the same place of love. Why? I mean, Tamara said it best last night. She said, the thing is, we love our people. We do this work because we love this country and we love our people. And that is the foundation with which this handover is taking place. So a couple of administrative things. If you want some Wi-Fi, the Wi-Fi is called @Santon. There's no password. You can just jump onto that. The toilets, I hope you found them. Some are on the right this side and at the back on the right. And we have a YouTube live stream. So if any of you have colleagues who couldn't join us today, they can just jump onto the YouTube live stream and be able to see what's happening in real time. So I can see there are some new faces in the room, some people who didn't experience what we went through yesterday, and I'll take you quickly through a couple of themes that were highlighted. So first and foremost, we heard from the Minister and Thembi Nkosi. I think Thembi will be continuing on some of the themes that he brought up in his first address to us yesterday. One of them being institutions matter. And that is the first plenary we'll be having today, thinking about how to build strong institutions. We'll hear more from the former commissioner on that. The minister gave us amazing updates, one of which was that he's publishing regulations on ministerial involvement in merger control, which I think is very welcome to business. We've been criticized for perhaps executive overreach, and I think that this is a welcome development to be able to assure the international community that, involvement need not mean overreach necessarily. And I think that I hope the regulations will provide some guidance on that. We heard on concentration in the South African society, and as Songezo pointed out yesterday, it was about 4 hours before we heard from our first brilliant woman yesterday in the form of Pam Mondliwa, as well as the remaining members of the panel. I certainly know that Pam has many a fan in my colleagues sitting on the corner. We also heard about regional integration and the African Continental Free Trade Agreement, thinking about ideas around, how do we meld, and I think the rubber really hit the road on this project when there come those moments where there's national interests that may or may not conflict with international ones. I think as South Africans, we may need to think quite deeply about whether we're going to be short-term in our thinking on that or long-term, and what would be most beneficial for us in either scenario. We also spoke a lot about the global food crisis. And, this is the benefit of these kinds of conferences. Because, I was at the tribunal when we did the price gouging implementation and the COVID consents and complaints, but it was only while listening to the panel on the food crisis and climate change that I was like, price gouging is going to be pretty important when we're thinking about climate change and food shortages. So there's so much ambit for our work to be able to serve people. And finally, we heard from those who wrote a book. Unfortunately, we only had one copy of the book because of the global value chains that they were discussing right on the stage. And thereafter, we had a beautiful gala dinner where, again, I think one of my highlights of last night was being able to see grown men express admiration for other grown men. And that made me think, you know what? Masculinity is growing. They're joining us. Let's love, you know? Okay, so jumping into the program, we are starting where I'm sure you all have been dying to start, which is, who is the new commissioner? But not just what's her name or what's her accolades. Who is she? We really want to know. And so that is what is first on the agenda today. So fitting. It is her first day in office. It is the first day of spring. She is the first woman commissioner. And on that note, I invite you and former judge, retired judge, sometimes an office judge, Dennis Davis, to the stage. Thank you. Please join me in welcoming them.
Let me start, firstly, by saying, as I indicated you, Commissioner, which is what your name is now, that this is not a judge for yourself program, and it's not my job to cross-examine you. But it is my job, it seems to me, firstly, to congratulate you. I think the explosion of enthusiasm indicates the most remarkable feature, which is, and the minister made a point last night, which I think is absolutely right. It's easy to appoint people, but very difficult to appoint really great people. And to have had Thembi and now you, that's an achievement of the minister. I have to give it to him. So let me start by saying, you and I go back a very long way. You think it goes back further than Carefan, which was in the 1990s.
Good morning, Judge David.
You've been very polite.
We had a debate whether I have always called Judge Davis Dennis, and whether today I call him Judge or I say Dennis, but I'm sure I'll use it interchangeably. But firstly, I just want to say good morning to everyone and thank everyone for coming around. And thank everyone for the welcome. It has been quite overwhelming, and I really appreciate it and look forward to working with each and every one of you. Dennis, I did meet you as a candidate attorney at Cheadle Thompson and Haysom in 1997. It was quite remarkable for me as a candidate attorney. Because we were doing an important matter. It was the certification of the Western Cape Constitution. It was a matter that had to go before the Constitutional Court. That's right, yeah. Yes, and in that matter, for some of you who would not know, at the time, Dennis was still practicing as an advocate at the bar. And you were led by Gilbert Marcus in that matter, and I was the candidate attorney in the matter, and it was quite fascinating for me, yes.
But the one that I do want to talk to you about, because it seems to me mention was made last night by David Lewis about Thembi taking, I think, one of these merger cases, and why I want to go to the Carefan case, because a lot of people won't know, and they need to know this. So Carefan, Advocate Ngotoibi, who practices in this area, will know this well, was a leading case dealing with the question of the review of the CCMA, etc. And I got a phone call when I was on sabbatical in London from your senior partner, Cheadle, to say, would I take the case? I discovered I was the 27th person that they'd approached. But so that wasn't the point. Point was, I said yes. And then in typical style, Cheadle disappeared. And you were a candidate attorney. But if I remember correctly, you actually conceived of the argument. It was you who kind of fixed up the heads and the papers. I am right about that, I'm sure.
Actually, it first happened in the Western Cape Constitution, the certification of the Western Cape Constitution, because one of the arguments we had to talk about was the definition of structure. And I remember working the whole night in typical fashion with Halton Cheadle, was Nikki Howard, who was an associate at the time working with me, and Halton had to work the whole night to wake up the arguments. And we did that, and in the morning, Nikki said to me to tell Professor Halton Cheadle what the argument was, and he said, "Oh, where did you get that? You are a candidate attorney, you could not have come up with that argument." And needless to say, he had to buy me a cappuccino because it turned out that I had. But I think what is important, Dennis, is to talk about you and Carefone and how you found out that you were like the 21st senior counsel we had looked for in that matter, because our papers were late and we had to do a condonation application. And in the application, which you had to argue, you found out that we had looked for all advocates who we thought were appropriate advocates at the time, and we couldn't find them. And you were our last resort.
Yes, correct.
At the time, yes.
That was why I depended on you. So I want to just talk about Cheadle Thompson, if I may, because there's a curiosity here. Your predecessor, Nkosi, was a Cheadle Thompson. You're a Cheadle Thompson. What is it about Cheadle Thompson and Haysom that essentially, which was, to the best of my knowledge, and he's one of my closest and dearest friends, well, in fact, they all were, Cheadle, Thompson, and Haysom. I don't think one of them would know the first thing about competition law. So how on earth did it happen that we've landed up with two commissioners who, and particularly yourself, how did your career come about that you worked in a firm which was ultimately a labor law firm? And now, in a sense, like your predecessor, you become a leading figure in the competition world. I mean, what was it about that firm? The experience? Was it the way they litigated? What was it about the firm that you took with you through your career?
So the firm is a very interesting place for anyone who's worked there, and it's not just Tim.
You ended up being the senior part, the chair or the C partner.
Indeed. Yeah. So there are many trailblazers in the competition law field who came from Cheadle's. Justice Norman Manoyem, who was together with Dave Lewis responsible for the Competition Act we have now, together with tribunal member Yasmin Karim, who happened to be my supervisor at Cheadle's. And I just wanted to let case managers at the tribunal, don't worry, what she's doing to you, she did to us at the firm. Yes, it is so typical of a tribunal member, Karim. I did warn her that I was going to tell people about her behavior. And of course, you had the chairperson, the current chairperson of the tribunal. Most people do not know that Mondo Mazwai was a candidate attorney at Cheadle Thompson and Haysom, and an associate, in fact, at the firm. She was a year, in fact, ahead of me, having been a year ahead of me at the university. So she was a sister and a leader in the firm. The thing about the firm is this, Dennis, is that the firm throughout its existence sought to use the law to achieve social justice. That was at the heart of what the firm was. So to the extent that we practiced labor law, it was in order to achieve social justice. And it was befitting that you would have people like Norman Manoyem, due to the human rights work that he was doing at the firm, that they would write the law. And so because we were privy to the drafting of the competition law and competition policy, we were privy to some of the workshops that happened and how we wanted to use competition law as another tool to achieve equality, inclusion in the economy of South Africa. So it is not surprising, in my view.
Yeah, I mean, when I listen, of course, you're quite right. All of these people, Cheadle Thompson, is a real case of abusive dominance. But let me ask you this. I mean, there are two questions that flow. The first is this. Both you and Thembi strike me as incredibly organized people. When you were... Thank God for you. Brilliant. I kind of knew then that you were going to go places. But how is it the two of you, who kind of really worked in this chaotic firm, because although Cheadle is probably, in my view, the most strategically brilliant lawyer of my generation by a country mile, organization isn't his forte, right? And so how is it that you guys were so, you're so organized and so kind of systematically, I mean, it couldn't have been through the firm, for goodness sake.
It was, actually. Halton was an amazing brain. Yeah, sure. He really was. And one of the things I learned when I was managing the firm was that, in fact, as a leader, you need to look at the best skills and assets that your people have, and to the extent that there are flaws, how do you help them to get the best out of them and give them the support they need? And that's what someone like Nikki Howard would have been, someone like me would have been, to provide that support so we could get the best out of the mind of someone like Halton Cheadle. And it was an honor to work with him.
It's a great point. And I should say, apropos the Carefund case, because I want to move on, is that what was amazing to me about that case, and you may not remember, was you and I sat there for hours on end and we cobbled together the argument. And then Cheadle reappeared, as he would, right at the end, to tell us that we were completely wrong and that it was complete rubbish that we'd written and that he wanted to do it. And you stood your ground and said no. And we actually stayed with the argument that you did. And in fact, to be perfectly frank, if the court had accepted your argument, not mine, the law would have been a lot more coherent than it had become, thanks to Cameron and Meyerberg's rather incoherent effort. But that's another matter. I want to just ask you this, though, from your strategic point, Doris. Not only do I take the point, I think it's an incredibly important point that you've made, and I want to capture, if I may. This point that that firm and all of you who were part of it were part of a strategic operation. You kind of understood incremental change in labor law. You started with the basis that if you could get, and I see Tony Enrach that would know this well, if you could get, for example, union people into the factory, you could then get other rights, the rights to consult with workers, rights to have meetings, and eventually you get to the right to strike, and eventually you get the full panoply. I'm struck, you talk about competition law in the same way, but would I be right in saying we haven't quite seen that same sort of strategic exploitation of competition law in the way that you guys did labor law? That kind of incremental thing where you've got a vision as to where you want to go and you do it in baby steps, if I could put it that way.
I don't know if you are right, Dennis. I do think that maybe it's not at the speed we want to. And I think Dr. Simon Roberts raised that issue yesterday, the urgency with which we need to be moving in getting to an ideal situation. But I think there have been baby steps towards what would be an ideal economy where we have participation, where we have inclusion in the market. But I think we are working towards that, and I think there's been a lot of jurisprudence over time which you have been part of, and the work of the Commission, I think, has been quite incredible in that way, and I think we will get there. I was remarking to to James Hodge earlier to say, you know, someone is right. We are not going to, we don't have 10 years to set precedents on the new amendments. For example, there is an agency, we are in a crisis, our economy is in a crisis, and in order to make sure that the outcomes you're talking about are realized, we're going to have to move a little bit faster. And I think what the Commission did, together with with the Tribunal and the CAC during this COVID crisis, was to show that there is capacity to try and deal with matters as efficiently as possible, to try and deal with the problems we have. And I think if we could learn and use those lessons that were learned in this period to try and implement the amendments, we could deal with the issue that Dr. Simon Roberts raised yesterday of urgency, which I think is quite true.
No, I think that's absolutely right. And just to make a comment on, just to enforce your point, I've been struck by the fact that what all of you who in that law firm did was so revolutionary. If you take, for example, constitutional law, I don't see the same strategy. I don't see people having worked with the Constitution to kind of expand the rights to get there, in the sense of it's much more higgledy-piggledy. But I take your point in relation to competition law, and it's encouraging. I don't want to ask you on your very first day in office where you actually think the trajectory is going to go. If you want to answer, that's fine with me, but you don't have to. But I do want to ask you this. You are quite unique in the sense that, I mean, Thembi might, if I can't, he'll correct me if I'm wrong, but you are somebody who's actually litigated competition cases on both sides. So that puts you in a kind of unique position. I mean, I don't think anybody else has had that. And I'm just interested, what do you take from that, from your own experience? And we can come to some of the cases that your favorite cases, but what is it that, I mean, you've seen both sides. So what, I mean, you bring to the Competition Commission that kind of set of insight. And I'm just interested as to what you take from that experience of being both sides of the fence.
Thembi spoke a bit about some of the cases we did when I was at the firm. In fact, it's the introduction to competition law for me personally was from my experience as a constitutional lawyer. In fact, I think Mondo Mazwai got us to get involved in one of the first challenges to the Competition Act, constitutional challenges in Federal Mogul. You'll recall Federal Mogul was charged with resale price maintenance.
I do remember that very well.
And the tribunal found that they had contravened Section 5.2 and imposed a measly fine of, I think at the time, 9 million or 3 million rand. And what Federal Mogul did was to come to the Competition Appeal Court to say that Section 59 was unconstitutional in that imposing penalty which were criminal in nature and not administrative. And so that was my introduction, in fact, into competition law at the time, was to deal with the constitutionality of Section 59. So it was quite an interesting way to get into competition law through that. But the other way was through the trade union movement in major proceedings, as you would know. And I'm quite grateful to the trade union movement for actually pushing me to get involved in that. So what that did for me, Dennis, is that it allowed me to see the operations of the Commission on how they run their own cases, but it also helped me to see myself on the other side when I'm litigating against the Commission. And I have to say that, I mean, the Walmart merger is one case where there was opposite views with the Commission, particularly with Commissioner Bonakele at the time. We literally came and were quite vociferous in saying that there should have been conditions, and conditions relating to employment, particularly for the trade union movement, and I think that was a very important.
So what did you? I mean, I want to talk a little about the Walmart case, because, you know, we learned last night. The Minister talks about all these cases that were settled, but frankly, not one of those cases could have gone the way they did without the Walmart jurisprudence. That is the underpinning of all of these cases, whether we like. And you were central to that, because you were the instructing attorney for the unions, if I'm correct.
It is correct.
So what did you take out of that case? Now that, I mean, what do you think was, what were you happy about, what were you disappointed about in that particular case?
So I think before that measure, Dennis, there was the Metropolitan Momentum measure.
Yes.
And I think in that measure, the tribunal almost clarified the sort of steps you needed to take when you dealt with Section 12A, and that you had the competition inquiry, but you still had to go to the public interest inquiry. When they implemented the Walmart measure, and you rightly in your judgment in Walmart were deviating a bit from the momentum test, but you then got it right in Walmart. And I think for me, there are a couple of things that I will say about Walmart measure was participation in that measure was very interesting to see the unions participating in what would be regarded generally as a business transaction, and that in having workers as part of discussion about the economy, because they are participants in the economy, and that what we got out of it was the implementation of public interest provisions of the Competition Act, and I think that got clarified. And in fact, if you look at the measures that have subsequently come, often merging parties will in fact provide you with those conditions and the guarantees that were in fact solidified in the Walmart measure.
But I'm just interested because instructing attorneys, contrary to the conventional wisdom, are often the crucial player in this. In fact, my own experience of 20 years on the bench in competition law is often the attorneys know a hell lot more than some of those counsel argue in front of us. And no disrespect to certain people in the room, right? Perfectly competent. I'm not talking about them. I have a category of people I have in mind. But the point I'm making, which is important, is there was a very sophisticated argument that you people developed, and great credit to James Hodge, who was your economist. But it was your side that tried to give us some evidence about balancing, as it were, price decreases that Walmart could give against the loss of jobs and small, medium-sized businesses. I mean, it does seem to me that issue is not gone away. It's still there.
Yeah. Firstly, to your point about attorneys, I think what had happened, and this is credit to Chilo Thompson and Haysom, is that the lawyers at Chilo Thompson and Haysom know that you are not a passive participant in litigation. You are at the heart of litigation, and that the support we get from counsel is quite useful, but you need to know what you want to do for client. And I think it is a lesson we learned, and in fact is part of why Tembi would have stood up in the Sasol engine merger and would have argued the matter. We'll come to Tembi a little while later. But I just wanted to say this, Dennis, is that we were, the trade union movement, and I need to give this credit, to the trade unionists who were involved in the matter. We could all take the glory as lawyers, but they knew what they also wanted. They are the people on the ground, and if there's anything I learned in my time as an attorney doing labor law, was that it is the shop factory workers who know the operations, who know how the business are run, and who are at the forefront of this. And it was, in fact, them who explained the evidence you are talking about that came, that is what we were weighing up in the Walmart measure. Just point of correction, Dennis, I know you don't believe me, but James Hodge actually was the economist for the minister. We used the evidence he led at the tribunal as the trade union movement, but actually he was the economist for the minister in that matter.
I thought Stiglitz was, but I can't remember now. I'm going. Anyway, doesn't matter. But he did make that argument, and that argument was presented,
yes,
and it was a very important argument.
It was a very good argument.
I'm told I've got a little time, so let me move on to another topic. You were part of the ministerial team which advised Minister Patel with regard to the amendments. There is a sort of irony about this all, isn't there? Because this is a whole range. I mean, the proposals of your group were influential. Now you're going to have to implement them. I bet you didn't realize that at the time.
I didn't, and I will. I nearly said regret, but I won't. But just to say, Dennis, it was an interesting time. The work that we did under the leadership of Michel Leroux was quite helpful in getting us to be here. And I think it was at an appropriate moment. We have had so many years of the implementation of the Act since its inception. And so we needed to look back and see, have we achieved what we needed to achieve? Are there gaps in the legislation to help us achieve what we want to achieve? And it was appropriate that at that time we would have these significant amendments. It is ironic that I now have to come and implement them, but I guess it's also a good moment for someone to come in. And so for me, what the amendment represent is a mandate, a clear mandate on what my role should be at the Commission when I arrive.
But can I just ask you one question on that? It does mean that you kind of almost uniquely placed this extent, that I'm assuming that when your team that dealt with these would have debated something which is absolutely profound, is where does competition law begin and end? Norman Manoia made a point in Walmart, which I think is well worth re-articulating, that competition law can make a significant effect, but it can't change the world alone. And he's right. So you must have had to debate and consider the boundaries of the subject that you are now going to be the crucial administrator of.
Dennis, you are right, but I think as the minister said yesterday of Tembi, we need to push boundaries, and it is an important thing to do, because we could, in effect, have left competition law or major regulation just within the bounds of consumer welfare, but we didn't. We chose a transformative agenda as a country on how we implement competition law. And so in that way, while the law is your parameters, the approach, which should be based on constitutional values, remain. And I think we, as practitioners and as adjudicators, we need to bear that in mind, that we are, and you said it in Walmart, we are using competition law to deal with some of the impact of the past that we've had.
I have one final question, because I'm told I've got to finish. There are many other things I wanted to ask you, but this question is not necessarily applicable to the Competition Commission, but it is relevant to the community. It's a point that I've banged on about for many, many years are briefing patterns. Now, why that's important is because unless you give people exposure, you don't get specialist judges and the whole thing collapses, and tribunal members, frankly. And I know the Commission's done well on that, but does it give you some anxiety that we're so untransformed in the broader competition community? The Commission is far ahead of the game. But I'm not talking about the Commission, but you do represent the communities, and you have been on both sides. So I am interested in your view.
Yeah, so Dennis, I think that's a debate not just in competition law. As you know,
agree.
I serve on the Judicial Service Commission, and it's so interesting every time we get either black advocates or black attorneys. The constant complaint is briefing patterns, and it is a complaint that has been there for a while. And I think it's people like Tembi, Mondo, Yasmin, who show that opportunities presented to the broader community can benefit us all, and all that is required is to provide people with those opportunities. And it should concern us all, not just the Commission, but
I couldn't
all.
agree more. I have two senior counsel here.
I'm trying to avoid that conversation.
No. But I mean, it's an
issues.
important point. I mean, we've got two senior counsel here who basically totally evidence, compelling evidence for the point. By the way, just finally, do you have to resign from the Judicial Service Commission now?
It is not relevant. It's a conversation I'm having with the Minister of Justice and the Minister of...
No, many of us would like you to continue on that, I assure you. There are not that many voices of sanity there, and you are one. But
I am not speaking for the Judicial Services Commission for purposes of this discussion, Dennis,
but I
will not comment.
But I think what this issue has illustrated, right, the whole discussion that we've had, and I'm getting beyond time, is just, if I go through, I mean, from labor law, and by the way, just why did you do tax?
Dennis, that is such an important matter. I actually I was wanting to do a master's, and I was debating with Judge Manoem at the time whether I do a master's in labor law, and the point was all the professors who could teach me all the best labor law were at the firm, so I needed to look at another area. But it was very interesting because my dissertation, when I was doing my master's, was on employee share ownership schemes and the tax implications of that. So there was still a societal justice issue, even in my master's in tax law, or the interest I had at the time at least. Thank you.
So let me conclude, because otherwise the chair here will start screaming at me. I just want to say this. Last night it was a very invigorating celebration of Tembi. I have no doubt that in 5 or 10 years' time, hopefully I'll be around, there'll be a dinner for you, and the same level of accolade will come your way. In fact, it's probably true to say, just listening to Doris, the vast level of experience from labor law to tax law to competition law to constitution law is just wonderful. Because the one thing I think we always forget is you can't compartmentalize law. The best lawyers are ones who are able to have a large vision and can lift their gaze. And that's what I think our discussion has shown the audience that you have. I cannot tell you what joy I have in saying on your very first day, congratulations, it's a wonderful, wonderful thing for the country that we have somebody like you to actually lead this commission. It's an extraordinary statement for gender and racial equality in our country, and more than that, it shows this. If you only look, we've got talent in this country that sadly we so often ignore at our peril. Congratulations. I look forward to watching you perform miracles in the competition space, just as your predecessor had done beforehand.
Thank you, Danny.
In all honesty, I'm having feelings. I've got goosebumps, feeling a bit emotional. Oh, man. I am so excited what we are going to do with our act. We are going to make it live. We're going to make it thrive. We're going to make it breathe. Okay, on to the next topic. We've got Plenary 4 happening now. And the topic is building state institutions, looking back over the past 9 years and lessons for Africa. I think, yesterday we were talking a lot about the implementation of the African Free Trade Agreement, and one of the things that came out of that discussion was a strong emphasis on the importance of having good enforcers in the various domestic areas in which the Regional Competition Act would have force. So in that spirit, I'm going to invite my panel members for panel 4. We have as our kind of chair of panel 4, or Plenary 4, Ms. Mondo Mazwai, the chairperson of the Competition Tribunal. We're ready for you now, Mondo. Please do join us. Thank you. And as our panelists, we've got the former Commissioner, Thembinkosi Bonagele. We've got Francis Kariuki, the head of the Competition Authority of Kenya. I am so glad to be hearing from our neighbors. Oh, not quite our Makelwanes exactly, but like jump a couple states. We've got Derek Schwartz, a professor at NMU, who'll be joining us as well as a panel member. And I understand virtually we've got Bill Kovacic, who I'm sure you're all very familiar with, a professor at GWU. So yes, he will be joining online. And I hand over to you, Ms. Mazwai.
Good morning, everybody, and welcome to this first plenary for the day, which is building state institutions. And I think it's apposite that we jump straight into it after the conversation that was had towards the end of the discussion between Dennis and Doris about capacity and building institutions, the legacy that Thembi has left, and the legacy that we hope Doris is going to leave, and I'm sure and have no doubt that that will happen. Congratulations, Doris. I'll take the opportunity while I'm on the podium to say 1st of September, new beginnings, first female, monumental. Welcome, Doris, to the competition authorities. So the topic of discussion is building state institutions, and in particular, we're looking back at the last 9 years, which Thembi has been at the helm as the competition commissioner. So we're going to look at lessons learned from that. And we have a panel that needs no introduction, and I'll come to that in a moment. So the purpose of this discussion is really to review the Commission's work. I won't test your memories. Last year we had a similar topic, but it was about building state institutions for inclusive markets. And so today the focus is really mainly on the achievements of the Commission and what we can learn from other counterparts in other jurisdictions. So we're going to start then with introducing the panel, which I don't think needs introduction. Those of you who were at the gala dinner last night will know that Thembi is a rock star, has been described as a rock star, and I echo that description as well. And so Thembi is joined by two iconic figures in competition law. And the first one is Francis Kariuki, who is the first Director General of the Competition Authority of Kenya since 2013. And then the second is Bill Kovacic, who is a doyen of competition law in the US and is well known to many. He is a professor at the George Washington University of Law and has held many different titles at the Federal Trade Commission, and more recently as a non-executive director of the Competition and Markets Authority in the UK. So we have the right people to be talking about this topic. And the reason the choice is that way is because each one of them in their own way are coming to the end of their tenure. Thembi's came to an end yesterday, and Francis's comes to an end at the end of January, and Bill's term came to an end in March this year. So they have a lot of insights they can provide as to what their views are on building state institutions. So without further ado, I'm going to open with a very broad question to each of the panelists and ask them to just tell us about what the successes and challenges are of building a high-performing institution. And then we will break it down from there. I'm going to start with Bill. I must say that and send Bill's apologies. Up until last Thursday, he was going to be joining us physically, and unfortunately, the storms in the US and in Washington, D.C., where he is, made it impossible for him to get his flight on Tuesday. So as we speak, Bill has had to be up early. I think it's about 4 a.m. where he is. And so, Bill, thank you for still making it possible to connect with us, and thanks to technology as well for making that possible. So I'll start with you, Bill. If you could then answer that question, what are the successes and challenges of building high-performing institutions?
Thank you very much, Mondo, and congratulations to Thembi and Francis for running the race with such distinction and carrying the baton to a new generation of leadership so brilliantly represented in the presence of Doris, as we saw in the previous session. My apologies again for the distant participation, and were it not for thunderstorms. Of course, we've had meteorological thunderstorms and political thunderstorms in Washington. The meteorological thunderstorms kept me here, but I'm dearly wishing that I was there with you in person. Mondo, let me mention 4 features of the experience in South Africa and in other jurisdictions that stand out for me in building successful, productive institutions. The first has been a theme of the conference and our session earlier today, and that's the crucial role of leadership. It's simply impossible for a jurisdiction's competition system to prosper without a commitment of the political leadership to put the best possible people in the senior leadership positions. Without that, the system can't thrive. If it were Formula One racing, you can have the best car on the road, but if you don't have a good driver, you will not achieve the greatest success. And I think it is a testament, not simply to South Africa, a powerful example to the rest of the world, to see how the nation has placed its very best and very brightest and most capable in the senior leadership positions of each of the major institutions responsible for enforcement. Tembi and Francis, in the case of Kenya, would not say this themselves. They are too humble. But as an outsider, I would say it has been a powerful demonstration to the rest of the world to see what superior leadership is able to accomplish. So a vital foundation for success is the selection of good leadership. And I would say when you look at the experience of 140 jurisdictions with competition laws, you see a very uneven commitment among governments across the world to put people of such capability and distinction at the head of their agencies. So that's an enormous advantage for South Africa. Second, a system only prospers with periodic upgrades. The entire area of policymaking, as is the case with so many other areas of economic policy, is inherently a process of experimentation. Testing different approaches, seeing how they work, assessing the quality of performance at any one moment, and deciding what to do better. I would say that if a system is not achieving upgrades roughly every 4 or 5 years, it's falling behind. And that's especially true as it tries to deal with highly dynamic commercial markets. In other words, if agencies cannot be as innovative and progressive in developing new capabilities and achieving upgrades as their private sector counterparts are in introducing new products or services, they will inevitably and irretrievably fall behind. So a second powerful lesson from the South African experience, echoed in many other jurisdictions, is that the process of achieving upgrades is indispensable effectiveness of the institution over time. And the only way that you get grades is to go through a process of introspection, self-assessment, that asks yourself in a very unsentimental and honest way, how could we be better? Where do we have deficiencies? Where do we have strengths to be reinforced? But only through a careful process of self-assessment and honest evaluation are the areas for improvement identified. And that culture of exposing oneself to improvement and to rigorous self-assessment is an indispensable part of good agency culture. The third ingredient is building the resources and the team necessary to do the job. The chair of the institution can't do it alone. The senior leadership suite can't do it alone. No agency can be successful without a deep team in the administrative and professional capacities to do the work. I would say it has been the experience of South Africa to gradually improve the team. I think a threat to the performance of the regime in South Africa, and perhaps in Kenya, and most certainly in any country, is the ability to maintain a professional staff that has the capacity to work effectively in the many challenging areas that the Commission seeks to work. And that is especially true as it pursues more ambitious measures. The more ambitious the program you undertake, the indispensability of building the team in order to go with it, and this requires a commitment of government once again to provide the resources to do the job. It is a hollow and ultimately cynical act by political leadership to demand the highest performance of a competition agency, but not to provide the means to do the job. So a continuing test for any system is, are you willing to pay for it? And to put the very best people on the field. The last item I would mention is the long view. A difficulty, I think, in public administration everywhere is to focus the attention on today's leadership in the future and to pose the question, what investments are you making today to make your successor's life better 5 or 10 years from now? And I think one element of the South African and Kenyan experience as well that stands out for me is that in working Francis and Thembi, you have had an evident eye on the future. Do not have a short-term mercenary perspective that simply says, what's in it for me? And how can I build a better landing place for myself when my mandate ends? Instead, I think a continuing question and attitude in the minds of these leaders and good leaders elsewhere is, what about the future? And that focus on the future induces you to keep asking questions about improvements, about getting necessary resources, to realize that the decisions you take today have a pivotal impact on the future, and some of those decisions must of necessity an investment whose benefits will not be immediately observable, but they will be observable in the future to those who follow. And I'd say with respect to all 4 of those characteristics, what is so heartening about the experience in South Africa and Kenya is that I think see positive developments on all of those fronts. And in that respect, it's not simply important for Africans, for Kenyans, for South Africans. It's an important example for the rest of the world. Thank you.
Thank you, Bill. There is quite a lot that you said there, and we'll come back to unpack that. But first, let's go to Francis, just to have him give us a view of what he thinks the successes and challenges are of building a highly performing institution, and perhaps also just speak about your experience in Kenya and what the challenges and successes were in that context.
Thank you, Mondo. That's a problem of resources, but sometimes we have that. But I stand here, and your question is very difficult in terms that you're telling me to blow my own trumpet. But on retrospect, is that I think I'm the only one who knows how to blow it. So you'll excuse me, I'll blow it. And my case here, I can say we are the youngest agency when I compare to what Bill has done in US. Thembi yesterday, he said he's leaving a young adult. And me, in January, I'll be leaving a 10-year-old. And so is that I was given the mandate to form an institution. So as a Director General, is that I was given a mandate by the owners of the law, and that is the Kenyan people and Parliament. And when I look at what the government wanted to do, they wanted to form an institution, and an institution which is credible and which has the capacity and the visibility to enforce the law. Number 2 is that they wanted me to enforce that law to achieve and to improve the welfare of the Kenyans. So I can say I was the Neil Armstrong, the first person in Kenya now to deal with competition law. And then I asked myself, there are 2 options, and Bill has indicated it, that you can decide just to push your own self-aggrandizement, or you build an institution for the future posterity. And I talked to one of my colleagues, and unfortunately, that colleague of mine told me, you are taken to court when you do something. And therefore, you have the option of not doing something. You know, if you enforce, you can be taken to court. And if you don't enforce, you can be taken to court. So that's, as Bill has indicated, out of 144 agents across the world, there are some people who choose the right, or rather what they think is right, you don't enforce so that you can be taken to court. And at the end of the day, you are earning your salary. But I ask myself, what is the success of Francis when he leaves the authority? Will I just be remembered as the first Director General who just earned payslip for 10 years and he just left nothing for posterity? And therefore I decided I need to take risks. And these risks I have to take is that it's for future generations to be learning about when they mention competition authority, they'll be mentioning like the first landing in the moon by Neil Armstrong, that Francis is the guy who did this. And that's the option I did. But the challenge now I encountered is that I had only 3 staff members the first few days. So what do? Is that I had to approach development partners who supported me. And I brought in somebody I saw here today, Professor Simon Roberts, supported by the World Bank, and he came to Kenya. And that's how we started building the institution. And then also I had my big brother, South Africa, that I could learn from them. Before we started forming the organizational structure, we came to South Africa. We went to the United States. We went to Australia because of consumer protection, learning from the big brothers and big brothers with benefits. And this is what has always been pushing us, that even when we are attending meetings, is that you don't just go there for those meetings, is that you are going to learn. And Tembi, by the way, that's why I always come to South Africa. I come to learn from you. Not that I like you a lot, but it's what you have done. And Doris will continue doing that. So the key thing is that that's the vision I had. But also the other issue is that there was scarcity of resources. And I realized that when you don't prioritize, you behave like a drunk driver. You're all over the road. So you need to be focused and keep on your lane. You prioritize areas which have the greatest impact to the common citizenry. In Kenya, we don't have the BEE in our law. But at least is that each and every year, the government comes up with a policy statement in regard to what it's focusing on during that particular year. And every enforcement we do is that we try to align it with the government. And that is not lack of independence. That is helping the government in power to, because you're a part and parcel of that government policy, but they are not telling you to achieve, not to take a certain decision. So you align your priorities within the government priorities. Then, of course, Francis is just the driver. And I'm not a very competent driver. So I have to get some co-pilots who have to come on board and tell me, Francis, you need to take that corner. I'm a reckless one. You have to take that corner at 120. Don't take it at 140. So I needed to bring in team. After I had prioritized my policies with the government, it increased my budget by 200% within the first 2 years. I brought in on board 25 staff members within the first 2 years. And we had a very elaborate recruitment and placement policy. But I would say that there was a challenge in the sense that when we were recruiting, is that we were thinking that, we have to recruit people who have knowledge on competition policy and law. But I realized these people are not many as such. And then even if they have, you can have the knowledge that you have done 2 units, 3 units, but you don't have the experience. And then you come being, having some ego that you're expensive. When I realized that I'm making this mistake, I started recruiting directly from the university. I made some savings in terms of the salaries and also in terms of responsiveness to the needs of the institution. And when you come to the Competition Authority of Kenya, you realize that 70% of people, they are about 36 years old. And that is the kind of responsiveness we have. The other issue I realized is that, yes, you're in a competition agency, but you need networks, not only within the government, but also with the National Assembly. And having networks, it's not, it's not losing your independence. It's having networks to know what is happening in Parliament. And also when you want to push, or to what Bill has indicated, upgrading, is that you have contacts in each and every part of the government. And that is how do you get a seat on that table? Nobody will ever invite you to that table. Is that you have to push yourself to that table. And then when you're on that table, is that you have to maintain yourself. So, advocacy initiatives. Look at what the government is doing to curtail competition in the economy. Give opinions unsolicited, and support it with research. And the moment they hear the Competition Authority of Kenya has taught, they always salute and say, yes, we've heard, and we are going to implement, or they just ignore. There's a saying in Kenya, a hyena talked to the stone, and the stone did not respond. The hyena said, I know you've heard, even if you haven't responded. So that is the attitude. Talk to the stone, even if the stone does not listen, you have talked to the stone. So we always give opinion, whether it's solicited or unsolicited. And with that, you gain credibility. And also internationally, when, if at all you are not listened at in your own home, but you can be listened outside, then the voice can come from outside. What did we do? With my friend here, is that we formed the African Competition Forum. And the African Competition Forum is that it was looking at the whole continent, doing research, learning what South Africa is doing, learning what Tanzania is doing, learning what Nigeria is doing. So that also is that we can get that kind of information and bring it to our policymakers. And I can give an example, is that we do the research in sugar. And I approached my government in terms of import duties on sugar. Tanzania had a better import rates, and the sugar levels, the sugar prices were lower than in Kenya. And taking into account that 25% of the disposable income of the poor people in Kenya is used buying sugar. If you reduce if you reduce the price of sugar, we could reduce the level of poverty in Kenya by 2.8%. And when you go with such statistics to the stone, obviously the stone will listen and it will invite you on the table. That's how I approach the whole issue. Has there been challenges? Of course, there has been challenges. We are operating in a political economy. We all operate in political economy. Is that nobody will lie to you that we never receive calls, that we need you to do 1, 2, 3, 4. But as a leader, is that you should not be arrogant, but you should be a strict of law, and also is that you should be accountable and transparent and predictable. That any decision you take, publicize it, so that people can be sure when we go to the Competition Authority of Kenya, is that this is what they did to A and this is what they will do to us. So that you can be accountable. Independence does not mean you are not accountable. We are accountable to the Kenyan people. Then there is the other challenge. So we receive calls, but due to our predictability and publication of our decision making, is that we publicize that. Then there's the other issue of finance. Resources will never be enough. And that is why I talked about prioritization. We have been prioritizing. And in the first years is that we prioritize on removing obstacles in government regulations. Now we are prioritizing, then the second round was prioritizing, focusing on the drivers of the economy, focusing on ways of reducing poverty. You know, that what tickles with the policy makers. Then the other issue is that we live in a region where there are always issues of governance. As Francis, is that I wanted to build an institution which will never have any case of governance, will never have any audit query, and I leave an institution which has never been mentioned with such cases or any audit query outstanding. That's the legacy I've always wanted to leave. Come January, I've put the plane on the cruising speed. The board is in the process of getting my successor, and within 2 years, I'll know whether I was able to build an institution which may withstand Bill Kovacic storms and turbulence, which he couldn't make. Thank you for now.
So thank you, Francis. Some common themes there, which we'll come back to after Thembi's opening remarks. Thembi, the Commission has been a resounding success under your leadership. And if you could also just share with us, to remind us where you started and what has been successful and what has been a challenge.
Thank you, Mondo. Just firstly to also officially hand over to Doris and to tell the staff that when there are glitches in running the conference, please approach Doris. First, we didn't establish the institutions. We found them there. They were working. So I would want to first acknowledge that we had that gift of a legal framework that establishes independent institutions. And they were there when I got there. And I'm going to tell you what we did to improve them very briefly. I don't have all the time. But without repeating what my fellow panelists have said, I also subscribe to the notion that of everything that's required institution, there is none more important than leadership. Leadership can make things happen or not happen. With respect, people are very important, but people, you can find them when you have leadership. Skills, you may not have them, but you can buy skills when you have leadership. So but what you can't buy, what you can't insource, unfortunately, it is leadership. Leadership has to be inside. And I think, taking from the topic that we must draw lessons for our countries as well. I think here in South Africa, what I see is the lack of authenticity in leadership is a big problem. The gap between the kind of public persona and what people in reality believe in. And the wider that gap we must mind. The wider is the gap between what people say they believe and what they actually do. And I have complained in the past also that meritocracy matters. Here, what we have seen, and it's something we need to reflect on a lot, especially here in South Africa. The best students coming out of university want to be employed in the private sector. Blue chip companies, this and that. There was a time when you could also go to SOEs, but I can tell you now, with their reputation, nobody wants to go there. So the best go to the private sector. The second best go to government as officials and so on. And the West become politicians in that order. And there's a real problem there. There's something that's not working. And then there is culture. Culture also is something that's born of leadership. It's about knowing we are here for a purpose and defining that purpose and getting everybody to buy into it. So enough maybe about leadership because we don't have time. Then there is strategy. There is strategy. Deciding what's important, what will really move the pendulum. When we got to the commission, I remember we had this discussion. I was an official at the legal department, and we raised this issue about prioritization. Can we actually prioritize? Can we say we don't want to do this case and we want that one? And I remember the advice of the chief legal counsel at the time was that no, you have to treat all complaints equally. The law says when you receive a complaint, you must investigate it. And after you investigate, you must take a decision based on evidence on whether you prosecute or not. In other words, do everything. That is the first thing we changed. We said, no, we don't have the time nor resources to be able to do everything. We will hear if this is a problem. We always get a response from the market. The market is called lawyers. We would get the best response, we'll get it from them. We said, no, we will prioritize sectors. We will prioritize cases. And actually, Dennis was talking about incrementalism. I want to talk a little bit about this because I think when you are in the judiciary, you don't know how cases start. You decide that there are cases that are going to go through court and there is a constraint there and you will know the constraints. But there are also low-hanging fruits that you can do on your own, and in fact, the courts are less of a constraint. You also decide between incrementalism and Big Bang, because you also do need Big Bang. So you have to constantly balance that. So what we did, we kept everybody busy with cartels. We were very aggressive on cartels. Because, why? It was low-hanging fruit. We realized that there were a lot of cartels and we could get evidence. When we did a raid in one of the firms in Cape Town, we go there, guns blazing. We start ransacking the place, as you do in a dawn raid. The the secretary, there was this white secretary, sort of says, irritated. What are you guys doing here? Of course, using swear words. I will not repeat. We said, no, we are officials of the commission. We are raiding the firm. Says, what are you looking for? I think she wanted us to get out of the place. We said, well, we are looking for information about collusion, cover pricing, and so on and so on. The moment we mentioned the word cover pricing, she pulled out a file and asked leave a file, and it was written, cover prices. This is where we come from. She pulled it out, and we said to the guys, it looks like the raid is done. We usually take a day and a bit in the office. So we kept everybody busy with cartels because they were low-hanging fruit, they were easy. In fact, what Dennis doesn't realize, we've achieved more outside of courts in cartels than inside courts. I think Doris mentioned the early fines, right? We've achieved R1 billion fine through settlements of cartel cases. And of course, we debated this yesterday. Often a cartel will be reinforcing a dominant position of a particular player and so on. So it's not a linear thing. But the point I'm making is that big bang is also important. Whilst incrementalism, your term will end whilst you are still wanting to develop a jurisprudence and you actually raise the awareness of courts without them being aware that there are in fact cartels in this market, and in fact cartelists can absorb big fines and skies will not fall. And so instead of the courts leading us, you lead the courts. Of course, you can't tell them that you are leading them. They have to see that there is a problem and the problem can be fixed. The incrementalism comes in many respects in the judiciary accepting of the standard. And often this happens in technical ways. So it starts by saying, how do you initiate a complaint, for an example? Do you write a piece of paper? How do you do the investigation? Do you tell the respondents that I'm now investigating you? I tell you, the courts don't understand this. There are people who thought that respondents had rights to be informed. You say, well, how are you going to do a dawn raid? You know, how are you going to do to have the degree of comfort that you can be able to effectively investigate using an element of surprise? How are you going to achieve that? So, but the courts had to start from there. How do you initiate a case? Up to a point of saying, when you refer the case, how wide or narrow can this be? That is the incrementalism, and I accept that that process is slow and painful, but necessary. So it's not about either or. It's about choosing what will achieve results now versus what is needed to develop and sustain the system over a period of time. I don't have time, I realize. Obviously, building institutions is also quite important. I'll just end, Mondo, by one example, because I think it's important. Part of the confidence you get is also learning from what others are doing. With cartels, because it's one of the success stories, we went here to the OECD the other year. I think, I'm sure I was with Simon Roberts. We took a train from Paris to Amsterdam, to The Hague to meet the competition authority of the Netherlands. It was called CMA at the time. We said, we are thinking about prioritization. They said, no, we've done that. And they were our age. We were established the same year. They said, no, we've been doing that for years. It's been hugely successful. The private sector has accepted. We lay out the agenda every year. We go public. We say, we are going to go for these sectors. So we were more confident when we came back about prioritization. They also told us something. They said, in the construction of the Schiphol airport, the airport in the Netherlands, main airports in the Netherlands, we found that it is in the nature of the construction industry to collude. So we suspect that this is happening all over the world. We came back to South Africa. We found a construction cartel within months. But we were also told something else as we were talking to the Dutch and the UK Competition Authority. They say that competition authorities, possibly with the exception of the US, don't know how to investigate cartels. You don't know because you are doing your kind of competition analysis using all the competition tools that are needed to do this, in your abuse of dominance, defining markets, bringing economists to tell you the theory of harm. Irrelevant for cartels. Cartels, you are investigating a quasi-criminal conduct. And people who come from that system tell you that you need special people who can think like criminals. Thank you very much.
Well, thanks. Thanks, Temi. It boils down to resourcing and being able to stay ahead of the curve in terms of being able to enforce competition law, because businesses adapt and change all the time. I think Bill spoke to that issue to say you need to be reviewing the institution every so often to see that you are still relevant. So I want to come to two issues very quickly. One is the one of independence. And I ask the question because, yes, we want to do these great things. And there's, independence is an important element that has come through from the conversation so far. The institutions and how you set them up are varied. Francis, you mentioned that your institution is still a young agency. And the commission, Commissioner, you mentioned that you found an institution that was already in existence. So I want to touch on the model for what you would consider to be the best model, bearing in mind that independence is a theme that you have all mentioned. There is the Kenyan authority, for instance. It does not have three-tier systems such as South Africa. And I want to just hear from you, Francis, about the maintenance of independence and how important that is and how it works within that structure.
Thank you, Mondo. Let me start by indicating is that I don't think there's any perfect structure for an institution. But there's what I may call the basic doctrine of architecture of an institution, in terms that an institution should respect the constitution of that country in terms of investigations, prosecution, and decision-making. At least an institution should respect that. Number two is that, from where I sit, is that structure also goes beyond the internal structure of the institution. What is the nexus between your organization and the main government? For example, in Kenya, I'll give an example, is that when we were forming the Competition Authority of Kenya, we strategically placed it under the National Treasury. Why? Because one, it cuts across all the economic sectors, and therefore the Competition Authority of Kenya was among the first among the equals in terms of the regulation. And therefore is that this issue of that the authority has primary jurisdiction in terms of the of competition regulation, it was even implied in law. Number two, why it was placed there is that all the agencies under the National Treasury, they are graded highly, and therefore their pay structure is usually higher than the other state agencies. And therefore, for retention purposes, is that we are able to attract and retain staff than the other agencies. Then the other number three is that, you know, in Kenya, if you realize, is that we amend law very easily, because we usually approach the Minister for Finance, that is the National Treasury, when he is presenting the budget policy, is that the amendment of the law is made to be part and parcel of the money bill, and therefore it's usually through the budget making process, and therefore we amend the law within 3-4 months. And so we had envisaged that when we were forming the structure. But even having that kind of umbilical cord with the ministry, in terms of functions, the minister has no role in terms of the day-to-day operations of the agency or implementation of the competition authority's decisions. The competition authority has a board in terms of policy, and that board is constituted of 9 persons. 5 persons are appointed by the minister but vetted by parliament, and 4 are from the government, key government departments. And this board is the one which appoints the Director General and pushes the name to the parliament, which vets the Director General. So you can see there's no relationship between the competition authority and the minister. Now it's the board direct to parliament. And then the Director General is the one who does the day-to-day activities who runs the day-to-day activities of the Competition Authority of Kenya. That is in terms of the administration. But in terms of the budget, I can indicate is that we are not we don't have that independence, because we get 85% of our money from the National Treasury. And there's always a question, should we be retaining our fines? And the question has always been, in terms of retaining the fines, are the agencies in the business of collecting fines, or they're in the businesses of correcting market distortions? Because we might be motivated just to collect fines without, focusing on other problem-solving solutions. Then also is that on a rational and selfish point of view, if you depend a lot on fines, and those fines you don't collect them, the National Treasury will never increase your budget. They'll always be telling you go and collect from the fines. So it's a balancing act, and that is why it requires a lot of leadership skills. And in terms of enforcement, I'll not dwell much on it. I know many Kenyan lawyers are listening. The Supreme Court of Kenya has already pronounced itself in regard to the structure of all the regulators in Kenya due to a case which had been filed by one party against the Capital Markets Authority of Kenya, and the Supreme Court pronounced itself, and we seem to be offending that Supreme Court pronouncement. I'll not elaborate on it, but we are in the process of respecting that that pronouncement, and it's in regard to separating the investigations, enforcement of our processes. So that's how we have approached the whole structure issue.
All right, let me just then turn to Bill on this issue of independence. Bill, you have served on the CMA as a non-executive board member. You've served at the FTC, and you've experienced different models. And can you just share your experiences of independence and what model you would say works? And I'm going to link that to funding, because independence and funding sometimes can get conflated. To what extent are you reliant on the funds of the body that you report to, and to what extent do you maintain independence in your decision making and the best structure to achieve that?
I always made exactly the right decisions. I want that to be clear to begin with. But I think the lesson that you learn in looking at individual authorities is that in every jurisdiction, there's a tension between the notion that certain decisions must be taken autonomously on the one hand, but on the other hand, the agency must be accountable to the larger public and has to be effective in its ability to persuade political leadership to give it the tools it needs to do the job. I think we tend to forget in thinking about independence, and maybe independence isn't the right word. It suggests autonomy, even isolation. You can't imagine in any system that a government would give a public institution a lot of money and a lot of power and not at least occasionally ask, what do you do with my money? What are you doing with the power I gave you? We have to be accountable for that. And as Francis, I think, was very skillfully pointing out, you have to have a conversation with the political leadership of the country in order to get resources and to get powers. Very few agencies around the world are independently funded. That is, through fees or other mechanisms. They have to go through a ritual, at least 1 year, of going to political leadership and saying, please pay my budget. And you can ask, ultimately, how independent is any institution that has to go begging once a year for the budget? I'd say there's a limit to that independence. I was always aware in dealing with political that I had to make a request. So I did have to listen to them. And I guess that the listening is important because, again, as Francis was saying, Tenby mentioned this as well, you do ask them for resources. You do have to ask them for more power. The upgrades I referred to before, you need to ask for more powers in order to repair deficiencies in the system. You only learn about the deficiencies in the system or its limitations in the course of applying them. You have to go back to government and say, I need a better vehicle in order to do the job well. And you have to be able to speak with them so that they have realistic expectations about what you can accomplish. I think that as new institutions are built and as they operate, political leadership begins to assume immediately that they can do everything. They expect you to cover the universe when you discover it's simply pretty hard to simply get to Durban. So managing expectations is part of having that conversation, and you can't have the conversation unless you are part of a process through which you engage with political leadership. So that element of accountability and effectiveness, I think, is very important for leadership to keep in mind. And by the way, it tells you something about who you want to have as the head of an agency. You want to have an agency head who in some sense is a political scientist, who has a broad understanding of the economy, of the structure of governance, of the locations of power in the country. This person is the equivalent of a great midfielder in the global sport of football who understands the entire pitch, sees everything, almost has eyes in the back of their head in order to see everything going on. In a way, that's who you need to head the agency, because they need this broad awareness. I'll simply close by emphasize one area where I think the agency must fight to maintain autonomy, and that's in the decision to prosecute. To do things that hurt by applying the enforcement tools that the agency has. That's where it's crucial that the agency build a reputation for exercising independent judgment. And the reason that is so important is that ultimately, you do have to go through the courts. Ultimately, you do have to go through the courts. Ultimately, in South Africa, Jasmine, Dennis, Norman have to have confidence that the agency is exercising independent professional judgment. Because notice one of the arguments that an agency makes when it goes through the courts is, why should you listen to us? We're the experts. We have deep expertise. So in making certain judgment calls and decisions, you should at least implicitly defer to our judgment. Give us a margin of discretion, because we are a repository of superior expertise, and the superior expertise guides our decisions. The court will not do that if it has the view that you simply are responding to the specific demand of political leadership in the country to take one path or another. If the court believes you are simply an extension of the political process, it will not listen to those arguments about expertise. It will have the listening ability of the stone that Francis mentioned in his example in the proverb. If the court does not think that you are acting on the basis of your strong political judgment, not your political judgment, your professional judgment in technical policy expertise, indeed, in a context in which you're aware of the larger social needs of the country, but if the court disbelieves that you are acting with your professional judgment and your technical expertise, it won't give you any difference. It'll simply say, you're making the same judgment as a legislator, a minister. Why should I listen to you? So I would say, in the engagement with political leadership, it is crucial to have that engagement. Otherwise, you don't get money, you don't get needed powers, but you have to signal to political leadership that when it comes to deciding to prosecute, bringing cases, doing things that hurt, we must act and must be seen as acting on the basis of our professional judgment. Because if that perception is eroded, the courts that ultimately have to uphold our choices and share our vision about where the law ought to go will simply shut us out. And in that respect, autonomy is crucial. So autonomy with respect to the decision to prosecute, vital. There are a variety, as Francis was saying, of institutional designs that allow us to do that. And I'm afraid in the answer to Mondo's very important question, is there a framework that operates better than others as a method of governance for the agency? I'd say our larger community around the world is still trying to figure that out. At least we're asking that question. So independence in the sense of isolation and detachment completely from the political process, it's not possible, it's not feasible, it's not desirable. But autonomy, making the decision to prosecute in each cases, that's vital if you're ultimately going to succeed in persuading experts like Jasmine, experts like David, experts like Norman, that the agency should be given the benefit of the doubt and its judgment respected.
Thanks, Bill. I want to turn to the last question, which is the question that's been touched on, and that's the one of resources. I think competition agencies in general do have a resource problem, and I want to ask the question to you, Thembi. Over the years, the Commission has grown in leaps and bounds. We've just touched on the issue of budget. How have you managed to attract staff, to retain the staff, and to be able to pay the staff, because funding is usually a challenge?
Sorry, I have an independent mic. Firstly, you have to be prepared to fight with National Treasury quite a lot because they'll tell you how much you must pay your staff. And so, again, in the context of independence, I think you have some scope there to put up a fight. I'm not saying you must fight to death, but you have to push back a little bit to be able to do this, I think, to be frank. The second thing is and by the way, it's the entire government system. The entire government system doesn't like autonomous institutions. You know, they want to compare salaries of the experts you pay in an agency to a sort of normal civil servant salary. So that battle is always going to be there. It's a little bit of a tension. The second thing is, which has helped us quite a lot, is it's really the credibility matters. Credibility matters to be able to be responsive. So the cases you do kind of respond to the needs of your stakeholders, society in general, but also policymakers. I think in South Africa, we've been lucky that at a time when everybody was facing budget cuts, we are probably one of the few agencies that were able to get an increased allocation. And I think that has everything to do with the value that is attached to the work we do. And lastly, obviously, you have to manage the resources properly. You know, it matters that you must have sort of credible financial systems, because you're not going to get money if you're not looking after it.
Can I just ask one last question related to that? I mean, how far ahead does one have to plan? I mean, you mentioned prioritization as one of the issues, and there has been quite a lot that has been happening in the world, in markets, in the economy. We know that things have changed. There's the digital economy, and it forces a different way of planning your resources as the Commission. There's food inflation that also hits you as you're thinking you are looking at digital markets, and so many others. So how does prioritization then work in that instance, and what would you say is a manner of attracting sufficient skills to deal with all those, and when do you acquire those skills? Because you don't know when you are going to need them. How far ahead do you need to be planning, and how did you achieve that?
Yeah, no, that's a really great question after COVID, because we had to throw away all the plans during COVID to refocus on other things. Fighting inflation is one of those things that tend to be urgent, because you can't wait. You know, consumers won't wait for prices to come down. So I think that you must still keep the long-term overall vision. So if you want inclusive markets, that's going to remain. You know, that's a long-term vision. But the things you do day to day towards that will change over time. I mean, what we did, for example, on abuse of dominance, which tends to be cases that take very long, and I think credit goes also to Liberty for this. We realized we were losing cases, and we were making a lot of investments. Even though these cases were towards the vision that we had outlined, we said, well, we need cases we can win, and we can win them without investing too much money. So we started taking cases people didn't think were important to establish precedent. So that's how you saw these cases about number plates, a simple contractual issue that's tying the market. It's not very difficult to persuade adjudicators about it, but it's got a huge impact on opening up markets. Rather than running a complex excessive pricing case, with the possibility that you are going to be second guessed by, especially, let me not mention names. But the point is, I think you have to balance how much you invest versus what you can get. And I think it's not always about the big and most popular cases. Sometimes it is small, but with a potentially huge impact. I mean, we did number plates, we did CompuTickets. I mean, CompuTickets, a fantastic case, also a contractual arrangement to lock in the market. And you get a positive judgment within 2 years that unlocks all of that, and you change the entire market. So it's also about how you deploy these resources, because you can have this excessive pricing case. It will tie all your resources, and it will take 8 years to resolve, and there will still be a debate, a big debate at conference with people emotional about whether you should intervene with prices or not.
I think we are running out of time. I'm going to ask Francis if you have a closing remark, and then we'll turn to Bill just to give a final comment before we close.
Thank you, Mondo. As my closing remark, and we are leaving with Tembi soon, to me is that I'm looking at it as an opportunity to bring in new leadership who will be able to respond quickly with the new emerging areas. We have seen that we are having data platforms, digital economy, and we are this kind of people who have been focusing on traditional sectors of regulating. We have seen even we may start breaking up institutional dispensations and bringing in consumer protection and bringing in data protection in big agencies. I think this is not our forte. You can see we are still talking about independence. As we move forward, is that there's going to be a combination and maybe bigger agencies. And I think new blood, new visionaries need to come on board and start this new era of enforcement, which requires a lot of cooperation, collaboration, and engagement with the regulated. That's the opportunity I'm seeing. Thank you.
Thanks, Francis. And Bill?
My colleagues, I think, have identified a vital frontier for work in competition authorities around the world. In the field of public administration, generally, I think there is still an epidemic failure to bring the process of strategic planning and project selection to bear upon the application of agency power and resources. I think in far too many instances, agencies operate like a fire department where the bell rings, you take the trucks out, and you put out the fire, you come back to the firehouse, and then the bell rings again and you go out. You have no time to think about why there's so many fires, how you can engage in fire prevention, do you have the right equipment, you have the right approach to dealing with fire suppression and fire prevention. And the comments that both Tembi and Francis have made about focusing more attention on how priorities are set and how projects are selected, to think more as an enterprise would or an investor would about where the rate of return is most appealing. I would say that the most heartening thing I saw at the Competition Markets Authority is how much progress they have made in building a better methodology inside the House to select projects to carry out broad priority. To realize, as Tembi said, that a small case can make big law, and you might want a small case in your portfolio. To have a process of asking, how much is the big case we're going to bring? How much is it going to cost? And what is the relative benefit of bringing that case compared to other things that we could be doing? CMA has gone a long way to building a framework in which individual decisions are taken in the context of a larger portfolio of matters already underway, and comparisons are made among alternative projects. So I think one thing that the panelists, my colleagues have done so well is to highlight the benefit there would be to, not just for Kenya, for South Africa, but for agencies more broadly, to bring comparative study and detailed examination to precisely the process that's used to decide, what am I going to do? How much will it cost? What's the anticipated return from carrying out the project? To think about a way of improvement our entire system in the future, that is an issue worth wrestling with in a far more aggressive way. Thank you.
Thank you, Bill. Thank you, Bill, for those final remarks. We have come to the end of the session. I'm sure it will continue outside on the corridors as we learn from each other. Enjoy the rest of the afternoon. Thank you, Mpumi.
Thank you, panel. Testing. You can hear me? Okay. I was instructed not to give you tea. But I'm a lawyer, so that means I aspirate coffee. I can't do it. I personally am a little pressed, so here's the compromise. In 5 minutes from now, I would like my panel members on the stage. And if you need, I know some of us, we're seeing like people we've idolized for our entire career just in front of us, and we really want to have that conversation, and you just want to hold them down and say, please, I love your work. You may do that, but here's the condition. While you're outside, it's actually quite noisy every time somebody opens the door, and it's very disruptive to the panel. So if you are going to go beyond the bounds of time, please do so quietly. So while you're outside, just have a, whisper session with your idols. And we will start with the next session. I'm going to give it 1:45, so that's 7 minutes. Go. Thank you.
In a vote of confidence about South Africa's long-term prospects, New York-based food and beverages giants PepsiCo has made an offer to buy Pioneer Food Group, which makes Sasco breads and Ceres juices, in a deal worth over 25 billion rand.
The Competition Amendment Act came into force in July 2019. Barely 2 months later, a Simba Pioneer merger was notified to the Commission. So this was really the first time we had to, as the Commission, consider the implications of the new amendments, particularly to Section 12A3C and Section 12A3E of the Act. So this was really the first time we're looking at this case through the prism of the amended Act, and it turned out to be a seminal case in respect of those amendments. This case provided us with an opportunity to learn a lot about how to give effect to the promotion of a greater spread of ownership. So there was a fund created which ensured that there was skills transferred to youth, small businesses and firms owned by HDPs, teaching them farming and other general business skills. There was also funds set aside to ensure that small farmers can access markets. Insofar as workers were concerned, we had to consider how they can meaningfully participate in the economy. And again, here we eventually reached consensus with the parties whereby they set up a certain percentage of the shareholding in the target firm, which was to be held in a workers' trust on behalf of the workers. And this actually equated to a value of 1.6 billion, and dividends would flow to workers from day one. So this set the template for later cases, whereby when we involve workers and worker participation, we expect that there must be no encumbrances to that shareholding, and dividends must flow from day one. This case really provided a template from which we could take these amendments forward. And there were a lot of learnings. For example, we learned how to craft meaningful employee share ownership schemes that are truly transformative in the sense that they provide workers with board representation. They are unencumbered in the sense that workers can start enjoying the fruit of those dividends from day one. Some questions remain unanswered, such as, in which entity should workers participate in? Should it be an entity that is domiciled in South Africa? Can it be elsewhere? And these will obviously be further crystallized through the development of the jurisprudence. And I think we're looking forward to the conference where maybe some other views can be heard from labor, business, the legal fraternity, as to what their thinking is about how we can give meaning to these amendments. When I joined the commission in August 2021, 2 months later, the complaint in relation to the PCR test case was made in October, and I was brought into the case at the end of November 2021. The PCR test case related to the price charged by private pathology firms to conduct PCR tests, which is the gold standard for COVID testing. The Omicron virus had just been discovered in South Africa, so quite a lot of people had to perform COVID tests. At the time the complaint was made, it cost 850 rands per person per test. So the complaint received from the Council of Medical Schemes was that the price of 850 was excessive when regard is had to the cost of conducting the test. So our brief was to investigate whether a price of 850 was excessive and to come up with a remedy that is either referring the case to the tribunal for prosecution for excessive pricing, or to try and find a settlement with the private pathology firms. My role in the case was just to do a deep dive into the numbers provided to the commission by the pathology firms. That is, to understand the revenues that they made, the costs to the labs of conducting a PCR test, to do a reasonable analysis between the price charged of 850 and the cost incurred.
Hi, can you hear me?
And
it's
also
Romaine.
what we had to do was just to do a comparison of the various cost items for the pathology firms to compare against each other. After we had established that the cost
Hello,
of
Romaine. This is Julie from
850
SAMR.
appeared to
We
be
are
excessive,
testing the
we had to do a
audio device
calculation
in
of
our
a minimum
conference room. Can you hear us
price
clearly?
that the pathology firms
Yes,
could
yes,
charge
we
for a
can hear
PCR
you. Thank
test
you very
and still
much.
remain
Okay, thank you very much.
profitable.
Also, just
The
speak a little
outcome
louder,
of
that would help.
the the settlements
Because
between
it's
the
a little bit
Commission
far
and
away.
the pathology labs, just in simple numbers, was a reduction in the price from 850 to 500 rand.
Can you hear me clearer?
But just at
this
a
time?
personal level, a week after the settlement was signed between the Commission and the pathology labs for the decrease in price, I myself had to undergo a COVID PCR test, and it cost me 500 rand. And had I gone for the same test just a week earlier, I would have paid 350 rands more. It is also important just to note that at the time, if anyone wanted to do international travel, they would be compelled to present a negative PCR test result. Also, at the time, if you wanted to be admitted to hospital for any procedure, you are compelled to do a PCR test to determine which ward you would be admitted to in hospital. So the reduction of the test price from 850 rands to 500 would have had quite a telling impact on society.
So in September 2016, the Commission received notice of a large merger in which Mediclinic South Africa intended to purchase an independent hospital group called Matlosana Medical Health Services, or MMHS. Mediclinic SA owns around 50 or so hospitals in South Africa, one of which is located in Potchefstroom. Now, both of these towns are in the Northwest Province. MMH operates two multidisciplinary hospitals in Klerksdorp, Wilmed Park Hospital and Sunningdale Hospital. There are, in total, in that region, about 3 municipalities next to each other. There are about 5 hospitals in the 3 adjacent municipalities. And so, post-merger, Mediclinic South Africa would own 3 of the 5 hospitals in those 3 municipalities. In light of this, the Commission recommended that the merger be prohibited, as it was more likely than not to lead to a substantial lessening of competition in the relevant market, resulting in a significant increase in the tariffs for acute hospital care for both insured and uninsured patients. I think when we first got the merger filing, I think it became apparent quite quickly that there was more to this merger than met the eye. I think we suspected that it was likely to be harmful for competition, given, the extensive body of research that was conducted in relation to the industry. But there was this pressure to almost evaluate it through a more narrow lens without consideration of the broader context of a healthcare market as a whole and the right to healthcare as enshrined in the Constitution. The healthcare market inquiry, as well as other research pieces and investigations in the healthcare market, have consistently found high levels of concentration and concomitant adverse competition outcomes in hospital markets. The CAC's decision to overturn the tribunal's ruling prohibiting the merger can be viewed as a sort of an offshoot of this approach, traditional approach to competition policy, which is why the Commission sought clarity from the Constitutional Court by seeking leave to appeal the CAC's decision. Indeed, the broader context of the healthcare market and the right to healthcare was a key feature of the Commission's application for leave to appeal. At the start of this process, a key consideration for the team in understanding the effects of the merger was the broader context of the healthcare market and the economy and the provision of health services. However, the primacy of this approach would not have been ratified by the Constitutional Court if the CAC had not overturned the tribunal's decision to prohibit the merger. The decision by the Concourt has provided much needed clarity on the correct
Testing,
approach to
testing,
establishing
testing.
overall impact of
Testing,
mergers
testing,
and
testing. 1, 2, 3, 4. 1, 2, 3, 4. Oh, we just have good problems. The good problems are we love talking to each other and we love the content. We want the content to keep going. We want to carry on socializing with one another. Good problems, good problems. I'm going to welcome people in, and then I'm going to hopefully, I hope they can hear me outside, because we did have a promise that those who are outside are going to try and keep it down so that every time the door opens, we don't hear the cacophony of noise and the cacophony of socializing and the cacophony of catching up and the cacophony of networking. All right. So this session, yeah, I can still hear quite a bit of noise outside. I think our team is going to ask people to come on in and remind them of their promise. We were all bore witness to the promise. Those outside need to just keep it down a little bit. They need to keep it down because this is the main stuff. This is the main stuff. All right, I'm going to jump in. Do I have those in the room with me? I don't know if I'm sure. Do I have those in the room at least with me? Okay, just checking one more time. Do I have those who are in the room with me? Thank you so much. Thank you. You can see I wanted to be an actress as a child. So this session is kind of the bitter pill we've had to swallow, right? It started in ANZAC, and I heard people say, oh, no man, the wrong judges and the SCA, they don't know what they took. They took the international law and they put it in our law. Is it part of our law? And I remember attending conferences even 2-3 years ago where the question was, is characterization part of South African law? Is it avoidable in any circumstance? But if you've been watching the CAC press, we know, Aranda, ouch, bitter pill to swallow, ouch, for those who've read that, ouch, I was the case manager on that, ouch. I swear, being appealed and having your thoughts over, it's quite painful. So there was Aranda. We had Tuavest, a little bit of an ouchie, a different tone, but a little bit of an ouchie. And then we had I&J, which was nice because it was like, yes, we scored a goal. As the tribunal, we scored a goal. So here before you, you have kind of a panel of litigators who I love hearing from. And first, I'm going to introduce the erudite, Mr. Majenge, who's going to be leading the panel today and facilitating the panel. Also on the panel, as you can quite visibly see, we have the well-esteemed Mr. Nukiai Toby. Nice to see you. And nice to see your hair too, because dreads on dreads, we connect. Isabella Kentridge, so lovely to have you, a young voice in the room, who is an advocate from the Thulamela Chambers. We also have, I mean, if you don't know this sir, if you haven't been on the other side of his dawn raid, then I don't know what you're doing, actually. We have Mr. Mohlala, and then we also have Miss LaRue, who we'll be hearing from, and it's good to have you all on stage. I hand over to you, Mr. Majenge.
Yeah, thank you very much, Mpumi. Let's not forget William Kovacic, I hope you are still with us, Bill, who is a professor of law and policy at George Washington University. Are you still with us, Bill? Thank you. Cartel law is now at an inflection point, to borrow from an expression used by the minister yesterday. Now, if we take inventory and look at and retrace the evolution of cartel law, I think we can draw a distinction between old generation cartel cases as well as the new generation cartel cases. The old generation cartel cases will be cases such as McNeil, Videx, RMS, the bicycle case, which coincidentally was prosecuted on our behalf by Michelle. Now, what characterizes this old generation cartel cases is an accommodative stance jurisprudentially from the CAC, and that accommodative stance was acknowledged by the CAC itself in the NPC judgment. Now we also see new generation cartel cases. These are cases that Mpumi has mentioned, such as D-Africa Pest, Tovest, and more recently, INJ. Now, what characterizes this new generation cartel cases? We see a clear shift in the pendulum. And that shift seems to be driven largely by this issue of characterization, which interestingly is a derivative of US trust law. So I think it is very much clear from this new generation cartel cases that cartel law is now in a state of confusion, and we need to make sense of it. So we have assembled a panel of sense makers to really help us to put Humpty Dumpty together again, insofar as cartel law is concerned. Perhaps let's start with you, Bill, in terms of how do we draw a clear line of demarcation between per se as well as rule of reason contravention. And allied to that question is the question whether characterization itself is not softening that presumption of illegality in relation to cartels. Bill?
Thank you, Mr. Chair. And again, my great pleasure in participating in this conversation, which has universal application. This is a debate that's going on globally in many jurisdictions, including the oldest. Anytime you have a bright line rule, which is the rule of prohibition that we call per se illegality, including the specific prohibitions included in the South African law, there will always be the question of whether the observed behavior fits within the rule. We can declare, for example, that an agreement among rivals to allocate customers or territories is always forbidden. It's forbidden based on a policy conclusion that such behavior far more often than not is harmful, and that it's not worth devoting effort to evaluate the effects of the rare instance in which it might be benign. So countries forbid horizontal market allocations. The question will arise in a number of instances about whether the behavior we have observed fits within the rule. Is this a market allocation? If characterization means that at the threshold of any case or any inquiry, we have to ask whether the behavior in question is properly labeled with the per se prohibition, that's unremarkable. That would be a first step in any inquiry where we have to ask, is this a market allocation within the terms of the specific statutory prohibition or within the meaning of a judge-made rule of the sort that is developed in the United States? So in that sense, characterization is unremarkable. It happens frequently. Perhaps it's inevitable. I think the concern is that it becomes a backdoor through which a broad assessment of the rationality of the per se prohibition is brought into question. And this is where the application of characterization can begin to fall apart. And I'm a great fan of comparative study. I welcome efforts by individual jurisdictions and their courts to assess the application of the law within their own jurisdictions in light of what others have done. It's a way of learning. It's a way of building on the benefits of analysis and experience in other jurisdictions. I'll simply say, as an introductory comment, I am somewhat concerned about the way in which the U.S. experience is portrayed in recent opinions. I think it misses a good deal of nuance about the way in which characterization has taken place. And a number of the conditions that courts in the U.S. have applied in deciding how to label specific conduct, I think, missing in some of the judicial treatments. And I applaud the determined effort on part of judges to understand this body of law and to apply it. I simply think that some very important qualifications that have emerged in the U.S. application of the concept have been missing. In short, is characterization unusual or alien? And anytime we have a bright line rule, we're going to have to decide whether the behavior that we're examining fits within the rule. That's unremarkable. The question is, what kinds of arguments, if taken into account in deciding whether or not the observed behavior fits within the meaning of the rule? I think I would share the concern just expressed that the process of characterization in the modern South African jurisprudence is being expanded in a way that not only, I would say, outruns what has been taking place in other jurisdictions, but calls it into question whether or not the legislative judgments embodied in the per se prohibitions are themselves wise.
Thank you, Bill. So Bill, in short, is telling us that there's a mischaracterization of characterization.
Well put, yes.
Advocate Nkoitobi, how should we draw this demarcation between rule of reason and per se?
Yeah, I mean, I'm very concerned that this doctrine, I call it a doctrine of characterization, is emerging as an untethered doctrine, primarily driven by the jurisprudence of the Competition Appeal Court, which again has no beginning and no end, and provides substantive defenses when the legislature has decreed that for certain infractions, when they are established on the facts, there should be no justifications or defenses. I'm also concerned about a second facet to it. Not only is it untethered in relation to the law, it is also compelling competition authorities in every case to bring in economic expertise. And that happens frequently, and in fact, it's been inscribed into the jurisprudence by the Competition Appeal Court. Now, where this thing has happened is, so where it began, everybody knows it was in ANZAC. The claim in ANZAC was that characterization was a necessary preliminary step in US law. But for what purpose? In order to establish whether or not a particular conduct fits within the per se rule, or whether it should be characterized under rule of reason. In this country, we don't have that problem because we have a legislative enactment in Section 41B, which has been a deliberate choice for horizontal agreement made by the statute. And before ANZAC, in fact, the criticism in ANZAC was that the tribunal had taken the terms of the statute and applied them. And then they said that was wrong because there is some other step that you must impose in addition to an analysis of the requirements and look at the facts. In Dawn, the CAC cites characterization in one paragraph from US law, but it doesn't apply it because in the immediate following paragraph, it applies European style, Article 101, which distinguishes between restrictions by effect and restrictions by object. And then it uses the guidelines on restrictions by object to determine whether or not a particular restrictive agreement is restrictive of competition by object. And it departs, and that is why it's untethered. It departs without any explanation from its origin in US law. Most recently, I know someone said, cases you are arguing. Yes, I'm arguing the case. Most recently, in INJ, and we've lodged an application for leave to appeal because we lost at the Competition Appeal Court. Most recently in INJ, we took the debate directly to the judges to say this doctrine has no foundation in our statute and it is not part of our law. How the CAC has responded is actually also interesting because no longer is it now saying it's necessary because it's borrowed from US law or it's necessary because it's borrowed from EU law. Now it says it's also necessary because it's part and parcel of the steps in contractual analysis and interpretation that come from cases like Endumen. But there is, of course, a vast distinction between applying a statute to an agreement and applying the text, context, and purpose of the agreement. That has never been a debate at all. So there are two problems with it. One is its untethered origins and the fact that it can be used to describe any conduct, it can be used to describe any relationship between the parties, and it can also be used to provide substantive justifications, trying to find redeeming features in each and every agreement. The second problem is the fact that it compels the application of economic analysis to each and every agreement, and there is no reason why in each and every agreement economic experts ought to be called. So I'm afraid, I think that it is blunting the ability of competition authorities to effectively prosecute cartels. And this is a worrisome development for me. I was listening yesterday, the minister was sitting here and then he was going on about how concentration, in fact, has gone up, right? So there is an urgency which does not seem to be appreciated at the Competition Appeal Court in using the instruments we have to dismantle cartel activity. Now, they will say it's because the Commission is not doing a good enough job. There is just no evidence of that at all. The problem we have is there is something happening jurisprudentially at the Competition Appeal Court. Look at the two cases most recently. One is Torvest. Hamilton, that's your case. But anyway, Doris is the commissioner. So I think I'll be forgiven. Anyway, welcome, Doris, to this position you are taking. So I'm not asking to be briefed by the commission, but I'm not leaving this brief on characterization. I mean, look at, this is the last thing I'm going to say, Max. Look at the characterization deployment in Torvest. There, it's not used to characterize the agreement. It's used to characterize the relationship between the parties, right? And then you look at INJ. There, it's deployed to characterize the agreement. And you look at Dawn, where it's used there to find out if the agreement has redeeming features, any redeeming features. So it's the untethered nature of this doctrine and the fact that it's blunting the effectiveness of what the statute actually had in mind. And that is why the justifications for characterization have been shifting. And most recently, it is now said to come from Endumeni. So hopefully, very soon, the Constitutional Court would set down a case on characterization and clarify whether or not the doctrine is part of our law, and if it is part of our law, where does it begin and where does it end? There are promising signs on that score because the most recent case we lost at the Concord, which was Aranda. Unfortunately, I didn't argue that at the CAC. I think Hamilton argued that. So fortunately, with that most recent case, the Constitutional Court sort of departed from its usual one-liner that says no prospects of success, blah, blah, blah. It now said the reason we are not taking the case is because the CAC did not find that you must prove effects. So that's already beginning to show that they will probably be gearing themselves to take a characterization case very soon.
Yeah, so Tebeka is essentially telling us, because I have to translate these things for myself, is essentially telling us that characterization is a sort of a jurisprudential amoeba. And what is happening is that the courts are in fact characterizing away from the law. Isabella, it's your turn.
Thank you. Well, yeah, when you're trying to find where the line is between a per se and a rule of reason contravention, I think the most help the jurisprudence gives us is it's between ambiguous and unambiguous, which is maybe not so helpful, because definitely what the Commission would see as unambiguous would differ from what a firm might, and in some of the cases, the tribunal has definitely differed from the CAC in what they would consider to have been an unambiguous conduct. But beyond the question of where the line is drawn, which hopefully we will end up with some guidance from the Constitutional Court to tell us where that is. But another question, I guess, is when is the line drawn in a practical sense? Because as we've been hearing earlier, a lot of competition prosecution is dependent on resources and prioritization, and I think it will definitely affect which cases are brought to the tribunal, whether they're going to require more investigation, what happens if the tribunal determines that in fact it requires a rule of reason, but the investigation has closed and the referral's taken place. How do you go back and remedy that? And also, yes, as Tembeka was saying, what do you do in situations where you're going to need to expend a lot of resources in the economic effects of a conduct and in doing sort of counterfactual effect analysis, which ordinarily you would assume you wouldn't be doing in terms of per se contraventions. So that's where I feel like a lot of practical attention is going to have to arise wherever the line is drawn.
Yeah, thank you. Yes, certainly. It seems then that the incorporation, from what you are saying, Isabel, the incorporation of the rule of reason in the per se framework will unravel cartel conduct. Mahale?
Maybe, Chair, I'm not usurping your powers. Maybe Michelle must speak first. Do you want to go first?
I'm the moderator, Mahale.
I know, Chair. So, yeah. So, let me start by saying this characterization thing, it's a problem. It's the biggest problem of our time, and I think we've got to resolve it if we were to sustain prosecutions of cartels. because at where we are now, it has made us weak in terms of enforcement. You know, you go, you do dawn raids, you get evidence, you come back, you refer a case, they tell you that properly characterized, this is not a cartel. There's never been a point when on these cases, especially from the CAC, that they are properly characterized, they are a cartel. It doesn't exist, it's not there. It's always properly characterized, it's not a cartel. So you have a situation where you have a commission that is tasked to enforce the law in the public interest, for the benefit of the public. So the work we do that to benefit the public, majority of which are poor people. They can't defend themselves on their own. They need agencies of state to defend them. And then you, as the agency tasked to enforce on behalf of the public, you take cases, you prosecute them, you get competent tribunal, the specialists, court, competition tribunal, agreeing with you that you have a case. These firms are guilty of contravening Section 4.1b. And then you get the appeal to the Competition Appeal Court. When you get to the Competition Appeal Court says, properly characterized, this is not a contravention of the law. They let them off the hook. So what is this? What is this that firms can't be found guilty? They can't be found guilty. So you tell me, what is this? Because they are never guilty. And we know what they do. We've got evidence, they collude, customers are suffering, you know, majority are poor. It's an old lady sitting in a village somewhere, just seeing prices going up. She doesn't know what is going on. We know. We take the case. We try to protect them as mandated by the law. And then we have a court that says, never says, yes, we agree with you. So what is this? Do we have to do this thing, or should we leave it? Because it can't be that all the cases we are bringing there, I mean, Thembeka argues this case, listen to him, the sense he's making when he argues them. When the judgment comes, he doesn't even talk to what he was saying. At some point, it's also just introducing things that the parties have never argued. So you ask yourself then, who is this, which counsel have argued this point that is in the judgment, that is the basis for the ruling? Who argued it? No one. So what is this? You tell me. You have ANSEC. ANSEC says nature, purpose, and effect. ANSEC is correct. They still say no defense for Section 4.1b. Correct. SAP comes, it says these distributors, they are existing because of SAP, therefore you can't say they are colluding. We accept that. Then the problem started with Dawn. Dawn says, no, the agreement is necessary to protect sensitive commercial information. Therefore, it's not a cartel. So it's a basis of saying this collusive agreement is not a cartel. Then you have Pest Africa, a council manager argued it. You know what it says? It says no. The person who completed the bid, see, these are two firms accused of colluding because they submitted bids that are the same in terms of price. It says the person who completed the bid is the same person. Therefore, these firms cannot collude. between each other because the one person completed the tender. So what it does, it then conflates, you know, the legal status of a company with that of a natural person. We are accusing the companies of colluding. Then they say, no, the natural person completed the bids alone for the two companies. Therefore, this is a single economic entity. I mean, what is that? How we are being, you know, I don't know, we are being uneducated here. So, you know that a human being and a company, they enjoy separate legal entity. They are separate. You can't conflate a human being and a company. They have their legal status. But you have a judgment that says, no, actually that thing doesn't matter. These things are the same. It's characterization. This is how it works. Of course, I agree fully. It's an amoeba. We don't know. They will not. The next judgment will say something that you have never even anticipated. Any of us here. So then you have Aranda. Aranda says no, because this one is a manufacturer, this one is a distributor. We properly characterize this is a vertical agreement, despite the fact that they submitted the same bid. They were competing for the bid. They says no, they are in a vertical relationship. You leave it. Then you get the Tuavest. Tuavest says properly characterize. These firms cannot be held to be competitors because they were not competing prior to the tender. So when you were not competing prior to the tender, you can never held to be competitors, even if you were bidding for the same bid. And our argument is simple. You are bidding for the same bid, tender, therefore you are competing for that tender. For that tender, you are competitors. CAC says, if you have never competed before, you can never be held to be competitors and therefore not in a horizontal relationship. And there's problems there. Anybody who doesn't compete now, they can collude on a tender, they will never be found guilty of collusion because they were not competitors prior to the bid. Then West, you get ING. ING, West. It goes further. You know, you look, you say, okay, fine. I understand this one, I understand it. Now you have ING. Do you really understand ING? That you can collude and post facto say to a court that no, this agreement of collusion, actually, I was not saying it, I want to fix price. This wording misses not. So it's supposed to be, we agree not to fix price. It's written, we agree to fix price. And they said, no, we are missing a note there. We must put the thing and put note. Our intention was that we don't want to collude. That's why a note is missing there. With your permission, court, can we include the note? And then the court says, yes, you can. So what is that? I mean, you tell me. What is that? It's characterization. This thing, we've got to find a way of getting rid of it. Otherwise, then we must just close shops. Because, you see, what that court doesn't realize is that when it weakens the competition authorities unnecessarily with these obviously clearing things that we can see, what then will happen is that the consumers of this country are going to be exposed to the abuse of business. And that abuse, unfortunately, the majority of these people cannot fend for themselves. These authorities are created to defend them. So you weaken them, and then you are saying you are building democracy. What is that? I don't get it. Thank you.
Yeah. Yeah, Mahale has brought a dimension which I didn't appreciate, which is that characterization is now being used to pierce the corporate veil. I'm picking up some form of collusion so far in the panelists. Michelle, let's break this cartel.
Happily. When Bake greeted me this morning, he said, "You look like an angel in this white jacket." Clearly, my brief today, though, is to be devil's advocate to the Commission's approach to characterization. So let me seize my brief with some relish. And I want to make 3 points. The first is, it's not surprising to me that we're having this debate. So when Bake introduces the panel and says, first-generation cases, hardcore cartel, successfully prosecuted by the Commission, including the characterization principle, and then describes a second generation of cases where the Commission is losing. The Commission is facing headwinds. So let's try to unpack, the first point I want to make is try to unpack why that might be, and it's not because of characterization. So the Act's been around for 25 years. The hardcore cartels that were high-profile, successful prosecutions, Bread, I think, was probably the first one that was really front-page news and went all the way up to the Concourt. The construction cartel and the Commission's fantastic fast-track settlement process, showing the extent of collusion that happened leading up to the 2010 World Cup. Criminalization then comes in. So any business person paying attention and reading the newspaper now knows there's this thing called cartel conduct. You pay enormous penalties, as we saw in the construction cartels and in Bread. And now I face criminal prosecution if I'm involved in this. We know that the Commission, and again, it's not a case of we're never winning as the Commission, when we're always losing, because the Commission also routinely successfully settles Section 4 cases. So we know that there is still a successful track record for the Commission in cartels. But at this stage of our competition jurisprudence, at this level of awareness and consciousness and sophistication of the advisors to business, the type of advocacy that the Commission has done around cartel conduct. I mean, last week's Dawn Raid is making people go to their attorneys and say, am I guilty of a cartel in their industry, right? It's back on people's agenda. So it's not surprising to me that the Commission, without leniency applicants, isn't successfully prosecuting cases. There might be a different explanation for what's going on here than characterization being the problem. So the Commission's framing on this panel so far has struck me as one of the, that classic example of selection bias. You've probably all seen this thing. It's the diagram of the airplane that comes back from World War II sorties. And it's got the red dots where, the plane came back from flying in World War II. And they analyzed where all the bullet holes were and they reinforced that part of the plane. The problem is, what they should have done is worked out that it's the opposite. The plane was getting hit in the other places because those planes didn't come back. So let's look at the cases that the Commission is losing and work out whether it's because it isn't in fact a cartel, maybe. It's not the problem of characterization. So the first point I want to make is, given where we are in cartel enforcement in this country, it is a luminously successful track record by the Commission. And it's not surprising to me that in the third decade you would start seeing a decline in hardcore cartel conduct. What does that mean? That means we might have to do more 4.1a cases as the Commission. So there used to be a practice, back when I prosecuted bicycles, right? You pled in the alternative. It's a 4.1b, alternatively a 4.1a. Now, to put it crudely, again, embracing my devil's advocate role here, the Commission seems allergic to doing effects-based analysis. They say, oh my God, we can't do an effects-based analysis, it's a 4.1b. What's so hard about an effects analysis? The Mergers Division does it all the time. The abuse cases that are brought, we do effects analysis all the time. Market inquiries are effects analyses all the time. It's not that hard. So perhaps, given where we are as a country in cartel enforcement, I would suggest that we need to reflect on whether we need to start looking at bringing more 4.1a cases. There are these more marginal questions. There are these arguable cases. The reason the track record of the Commission at the moment isn't looking as good as it did in the first generation of cases isn't because the judges are biased and against them. It might be because these are tough cases. So you win an I-way, but you lose an Aranda. You know, you win in the tribunal, you lose in the CAC. It's because these are very exquisitely balanced, complicated, nuanced questions. So if only it were as simple as picking up the agreement going, oh, it's competitors discussing price, it's price fixing. Unfortunately, the world's not that simple anymore, I don't think, given where we are in cartel enforcement in the country. So the second point I want to make that flows from that, and seizing the opportunity of the fifth commissioner's first day, and leveraging off the previous panel, which was a fascinating step back to look at the questions of institutional design. I want to make a point here to say the way the Commission approaches cartel enforcement seems quite siloed off from the other enforcement action. And we saw how Magale and his team used all of their skills in the COVID excessive pricing cases. They were redeployed into COVID excessive pricing cases and produced settlements that were effective interventions in timely fashion. They produced a raft of consent orders that the tribunal confirmed. So I want to raise a question and say, well, why shouldn't enforcement sit together in the Commission? You know, why shouldn't we have, obviously there will be people with experience from cartel cases, but it makes sense to me that the Commission is structured to have people focusing on mergers, focusing on market inquiries. Why isn't enforcement sitting together as a way of thinking? And that brings me to my final point, which is characterization isn't special, and it's not special in the Act, and it's not special in the law. What do I mean by that? Characterization is in section 4, 5, 8, and 9. When a client comes to see me and they describe an agreement or a transaction or a relationship, an arrangement that they're busy engaging in, what's the point of that consultation? We hash out the facts and then we have a debate. Is this a notifiable merger? Is this a section 5? Is it a section 4? Does it in fact engage other areas of law? Should you be bringing a breach of contract case rather? Should you be going to a different regulator? Is this a delictual claim? That's characterization. So when the Commission applies Section 5, Section 8, Section 9, the merger provisions, the Commission's characterizing all the time. So let's not single out Section 4 characterization. The Commission every day, depending on whichever department you're in the Commission, you're doing characterization. That's the deal. You know, the leniency application comes in, the merger notification comes in, the whatever it is. The debate that's being had is, where does this fit in the Act? How do these facts relate to the provisions of the Act? So the first point I want to make is it's not special to Section 4. It's not unique in the Act. And the second point is it's not unique in the law. So Ndomeni and all the rest tell us, context, text, purpose. That's how you interpret statutes and apply them to facts. It's exactly what we're asking people to do. So I would say this is an opportune time, both in the trajectory of cartel enforcement specifically, but also in the life of the Commission as an enforcement agency, which, let's be honest, has probably the best reputation and track record out of all of the economic regulators in the country. I think it's an opportune time to take a step back and have a reflection on where we are in this enforcement and where we want to put resources going forward. Because the challenges of big data, big tech, because of the concentration of the economy, abuse of dominant positions, some of the fascinating public interest debates that are happening in the merger space, seems to me that the learnings and the skills that the Commission has, that it's honed over the years in mergers, could be usefully used as a very effective continuation of its track record into those other areas. So I'm pretty sure I'm not going to get any cartel briefs. But I hope I've lived up to my task today, which is to be the devil's advocate and say characterization might not be the explanation for the jurisprudential track record lately.
Yeah, Commission Michelle is saying if you can't dance, don't blame the floor. That these are Section 4(1)A cases or rule of reason cases that you have mischaracterized as cartel cases. Which brings us to the second question neatly and seamlessly, which is whether characterization is required as a sorting tool to sort out these Section 4(1)B hardcore cartel cases from the Section 4(1)A cases. What sort of analytical tool or framework can be deployed for the sorting function? Bill?
I think this is where an international perspective can be useful. Whether we're taking the framework under Article 101 under the Treaty of the Functioning of the European Union or Section 1 of the Sherman Act in the United States, both systems, one with a more specific statutory command that speaks about object offenses, the other with a common law developed framework that strongly resemble the list of prohibitions in 4B. In both instances, courts have developed, I think, some useful criteria that, to take Tim Vickett's point, to anchor and focus what we're calling the characterization process. And again, I'm using that term simply to recognize that, in the sense that Michelle was just saying, for an enforcement authority or court, you have to decide which label applies to observed behavior. My concern about characterization is it would depend a lot on the scenario we're talking about. The setting in which I would not open the door for exculpation is where, in a procurement context, for example, let's take three firms do compete with each other all the time. They have a tender, and they privately get together and decide who's going to win the tender, who's going to submit the bid. I would hate for there in court to be an elaborate assessment about their competitive capability and an inquiry that begins to examine the likely effects of their collusion. What would the counterfactual be? And I'm assuming for the moment that scenario is not at risk for purposes of enforcement here, but I would be worried if it was. That is, that the concern I would have is if the decisions involving the airport concessions, meatpacking, begin to open the door to raise questions about the effect of that kind of simple scenario, which in most jurisdictions gets condemned out of hand, in some jurisdictions sends you to prison. So what are the appropriate questions to ask to decide whether behavior is going to be put in the per se basket by reason of the statutory command or subject to a more elaborate inquiry? I think a key starting point is to ask, is the good pro-consumer, pro-purchaser benefit associated with the collaboration? And what's interesting, I think, in this foreign jurisprudence is that courts have identified a collection of arguments that are simply not recognized. It's not an argument to say, for example, that we weren't directly competing before. That argument gets zero recognition. The price we set is a reasonable price, no recognition. The petition is destructive because we can't survive in the business. That doesn't get any recognition. That is, there are a host of reasons often in characterization that courts have decided are not cognizable. And the jurisprudence is clear that if you make these kinds of arguments, you can save your breath. The argument that we take seriously is the argument that shows that the restriction in question was directly related to accomplishing a significant benefit for the buyer of the good or service. If we go to the airport concession example again, imagine that we have 3 smaller firms. None of them large scale of operations. None of them individually probably meet the tendering thresholds identified by the purchasing authority. And all 3 agree to combine for the purpose of making a single bid that combines all of their capabilities and resources, with the idea being that they were not able to collaborate in that way, they couldn't bid at all. That has a real benefit for the purchaser. This is another bid that wouldn't take place otherwise. The firms individually were not capable of submitting a bid. That's the kind of argument that as a pro-purchaser, pro-consumer, social benefit that would not be associated with a simple decision of 3 rivals to decide, let's determine which of the 3 of us is going to win in the tendering process. So I think maybe this is what happens over time. That is, in the next case, in the next series of cases. No, the only way to clarify this is to continue to bring the cases, seek the clarification. But the question worth focusing on is, let's agree that we, in some form, explicit or implicit, we have to decide in what channel the behavior is going to be analyzed. Is that process going to be an elaborate inquiry that draws in a lot of evidence, or is it going to focus very rigorously on the question of whether or not the restriction that was imposed has real benefit to the purchaser? I guess one way of asking it is, if the parties regard restriction as being so benign, would they tell the buyer in advance that they were doing it? Would they reveal that this is what we're doing? I regard that as a rough test of whether or not the restriction in question is good simply because it raises the profits of the party, or good because it's in the interest of the purchaser. But I think the lesson to be drawn from the international experience is that this process of labeling, of sorting, has been subject to a fair amount of discipline, to the extent that courts have been fairly rigorous in identifying what kinds of arguments entitle you to a more elaborate inquiry, what kinds of arguments are going to be dismissed out of hand. It's meant that cartel scenario I described for you before is litigated, because the parties know they have no good justification to offer, and they accept plea agreements, and in many cases in the U.S. they go to prison. It is only the scenarios in there is a plausible argument about benefit to the buyer in which a larger inquiry is appropriate. And I think it would be good if the jurisprudence is going to emphasize the characterization phase, these kinds of qualifications, I think usefully would be built in over time.
Bill, if I heard you correctly, you seem to be conceding that there is a limited role for characterization in its proper sense as a sorting tool.
Yes, that is there's always going to be a threshold question, except in some cases, about whether or not what I did is a market allocation. Sometimes that's going to be pristinely clear, and I don't even raise the point. That is because an amnesty applicant is a clear authority. What I know myself, which is I was just allocating bids, rotating bids, or it's unmistakable that the documents obtained, that folder that Don Reed, that Tembi was referring to before, spells out the prices we're going to charge. That I don't even make the argument at all. But in other cases, there might be ambiguity in that. And in that sense, you know, I'm imagining again the very simple initial question that comes up as I look at a set of facts is the behavior I've observed here properly called a market allocation or horizontal price fixing? But in large body of cases that we usually put in the category of cartel agreements, there's no ambiguity there. That process of characterization happens in the blink of an eye, because we know right away that that's the basket into which the beef goes. I mean, the European court case in Carte Bancaire, this is the Article 101 case, simply makes the point that sometimes the objects are immediately identifiable there. And the sorting process takes place almost instantaneously. So much so that you get settlements, plea agreements right away. But there are other instances in which there is more ambiguity about what happened. And it's in that instance in which a more elaborate sorting process might take place. I'm simply, maybe the vocabulary here is what gets in the way. I'm simply saying that if you have legal command that attaches decisive effect to whether or not a collection of actions fits within a category of conduct, there's always going to be an initial process, sometimes very fast, sometimes more elaborate, in which we decide whether the behavior I engaged in fits in the category. To that extent, I would say characterization is inevitable, but sometimes it happens with the speed of light, and it doesn't have to be more elaborate than the speed of light. And the jurisprudence, certainly in the United States, increasingly in Europe, recognizes that the opportunity to offer a justification is very strictly conditioned by the type of justification you offer, and that there are a host of arguments made that are no longer recognized. And that means that because parties know you can't raise them, the process of characterization in cases moves very swiftly.
Thank you, Bill. I'm going to cross-examine Advocate Ngugai Tobi now. Do you accept, Advocate Ngugai Tobi, that there is a need for a sorting tool or the threshold question as Bill frames it? And if so, is characterization not supplying that sorting tool?
No, I agree. I mean, otherwise the entire analysis would make no sense. I think there are two things I want to say before I answer you directly. The one is that we must take seriously what Bill actually says about the US experience and how his analysis of the recent judgments by our Competition Appeal Court, in fact, are a departure from the American understanding of characterization. Yet, the anchor of South African characterization is US law. So that's salutary, what he's saying, and it's actually quite sobering listening to him. The second thing to take seriously in this conversation, again, it's not a controversial point because there is not, is the idea that characterization has had shifting explanations and shifting justifications, right? Sometimes it's been used to say that parties are not competitors. Sometimes it's been used in order to provide a redeeming feature of an agreement. And sometimes it's been used as a combination of the two, right? So the fact that you've got a legal doctrine that has no fixed anchor explains the frustration of the Commission about how characterization has progressively over time been used to blunt its ability to successfully prosecute.
Now, this is not a question about whether they should be using 41A or 41B. The question is, how should they prove a case under 41B? Because the case that is before the tribunal or before the CAC in a given case is a 41B case. So what we know from these two preliminary remarks that I've made is that it seems then quite common ground that the impact of the introduction of the doctrine of characterization has been to blunt cartel prosecutions. Now, you are asking us about the necessity of a sorting tool. Bill calls this a threshold question, and that is correct. But no one has ever argued that there should be no threshold. But the question is, what is that threshold? In South Africa, we have an act that tells us the first thing you look for is whether these people are competitors. If they are not competitors, and that is a statutory threshold question, that's the end of the debate. There is no need to relabel that as characterization. The second thing you have to look for is whether there is an agreement. Right? That's the big debate in Aranda, that you cannot just infer the existence of the agreement, you have to prove it. That too is a threshold question, without which you are not in 41B. And the third one is the agreement under one of the three categories? Now that too is a threshold question of fact. Once you have answered those three questions, it seems to me that is where the scope has been opened for an additional requirement to show that it has the character that is likely to impinge or restrict competition. But that is not in the Act. And this is not about choosing whether to apply the Constitutional Court, Supreme Court of Appeal judgments on the interpretation of contracts. It is a question of applying a statute to a set of economic relationships. So the threshold question is answered by the statute itself. If you are wrong on one, these are not competitors. You are wrong on two, there was no agreement. You are wrong on three, the nature of the agreement is not as to divide markets or agree on prices or collusively tender. That's the end of it. So the argument is that's the threshold question. And if you can answer that question positively, that's the end of the debate. Now, this is again not new. A proper analysis of the jurisprudence of the tribunal prior to ANZAC, and in fact, subsequent to ANZAC, because there was a point when the CAC became very upset with the tribunal, that it is not following its guidance on characterization. And then the tribunal tried to subsequently catch up with the application of the doctrine. Right? So again, this exercise I'm talking about has been done by the tribunal. And there has now been this new thing that is in addition to a statutory analysis. And that's where the objection is to this idea of a characterization. It's not to tell the Commission that it's better if they prosecuted cases under 41A or 41B. The question is, what are the elements of 41B?
Yeah, Thembeka has formulated then the, let me not call it characterization, but the statutory analytical framework that then ought to serve as a sorting tool then for distinguishing or drawing a line of demarcation between per se and rule of reason. Of course, as a moderator, I don't want to get carried away and say that I agree. Isabel, the threshold question.
The threshold, well, I think that while it's true that characterization happens in many sections and it happens almost organically in most legal discussions, there is something distinctive about cartel conduct which the Act and the jurisprudence has recognized, and that's what information is available and when is it available, because you can have a client come to your office with facts and you can have a merger application providing you the information. or leniency applicant who comes with information, and then, it is quite a simple thing to characterize where do we put this. But often with cartels, you face the problem of a secrecy or a lack of information, lack of evidence, and you have to, I guess, interpret where the act is leaning when it comes to that. Who gets the benefit of that tension? Is it to the benefit of the commission because it, faces the problem? Is it to the benefit of the firms because they're the ones without the statutory power? And again, I think that's a policy question and a legislative question. And I was also interested in what Bill was saying about the real question being, when it comes to a case, is there a benefit to the consumer ultimately or not? And I think that one of the questions that we're facing is when it's not a specific case, but the idea of a per se deterrence, where do you reach the line where there's a benefit to having a very strict limitation because you're able to have quite strong deterrence, and where do you have a problem of over-deterrence and in fact harm to the consumer by having too strict of per se rule? And again, that would be something for, I guess, economists to think about.
You are very tactful and very diplomatic, I must say. Mahal.
Yeah, you see, this debate of per se prohibition and rule of reason, I think it's going in the wrong direction now. You see, there's a view that we must take 4.1a cases, a rule of reasons, as opposed to taking 4.1b cases. So in other words, when we get a case, we must say we are investigating this case as a 4.1a. It's not a cartel. It's a 4.1a. So they want us to look at a different direction. So in fact, it's even getting crystallized that there's a call for enforcement to be merged. So they are saying cartels must join enforcement so that they can do a rule of reason analysis and stop policing cartels. You see, this is what is going on. So Doris, you've got to decline that invitation. It may be very tempting. I would advise you to decline it, because you see, when the Scorpions was effective, there was a call to disband them. It was disbanded. Then what happened? You are in a state capture. So you've got to be very careful about these calls. We can see them rearing their head. You can see this. Commissioner Vonagel, hardly a day of your work, your legacies they want to dismantle it. You establish the cartels division, now there's a call that it must be merged with enforcement so they can do a rule of reason, stop policing these cartels. Doris, I'm saying you must say no. It must never be, it must never be on your name. Whoever wants to do it, they must do it on their name, not yours. Yours is a no-no. So this is the thing we are dealing with. You see, this issue of characterization, rule of reason, wara, all these things, they are together. These things are together. The idea is to shut down cartels because they are effective in policing and prosecuting them. so that you can have an agency that is toothless, is not able to catch those crooks there and prosecute them. That is all. There's nothing like anything else. That's it.
Yeah, Michelle, I would like you to respond to my question. Not to Makgale. This is my question. I know as a senior counsel you'll find a way of responding to Makgale, but this is my question nonetheless. Is there no risk here that a statutory analytical framework is now being substituted with a non-statutory analytical framework, and of course that has all sorts of implications for the rule of law?
Short answer, not nearly as entertaining as my neighbor. No, it's not. 2 points why and where we need to go. The first is Section 4 in its entirety is policing cartel conduct, right? The fact that it's drafted into 4.1a and 4.1b is a feature of when it was drafted. We managed to leverage off the experience of the US and the EU and codify the hardcore, unlikely to have pro-competitive effects, unlikely to have redeeming features. Those are the 3 categories of conduct that we codified in 4.1b. Section 4.1a is a potent tool against collusion. Let's not pretend it's not. So the first point to understand is the codification of Section 4 still matters, right? The reason that it's split into the 2 categories is because we know there is a hardcore category of collusion that can never be defended. Everything else, we need to develop the law. That's what Bill's talking about when he's talking about how things are progressing, right? We just took advantage of the fact that the rule of reason per se distinction had been judge-made up until that point and codified where that development had got to by 1998. So we're always going to have debates. We're always going to have contested litigation because we have to still define where that boundary is in the more marginal cases. And so I want to make a related point, which is to say we're straying into this territory of, that famous thing where the US Supreme Court was considering when something's pornographic. And the pithy line was, I know it when I see it. But if you know it when you see it, then you're exercising enormous power, right? And let me give you another platitude. With great power comes great responsibility. So because you can criminalize, fine with 10% of turnover, and cause reputational harm, all of it utterly deserved. Let's be clear, utterly deserved. Hardcore cartel members must pay the biggest penalties, and they should, their directors who knew what was going on should go to jail. No one is here looking for a soft approach to collusion. It is correctly described as the worst of the worst. What I'm talking about is responsible regulation of the marginal cases, where, unlike the description that the whole panel's been using, where, it's a very quick sifting tool, it's a very quick answer to the threshold question, because you do know it when you see it. And that's why my colleagues who are based in Sandton consistently go to the Commission, go to Makgale and say, I need a marker. I need a leniency application. I need to settle with you because my client has contravened Section 4.1b, no questions asked. So when we are going to trial in front of the tribunal contesting a 4.1b case, it's because there are colleagues who are equally committed to upholding the competition law of this country, equally committed to making sure that people are held accountable where they need to be held accountable, but not prosecuted where they haven't contravened, because that is an abuse of the enormous power that the Act creates. So, especially in the context where there can't be a costs finding against the Commission and the tribunal. So the luxury of testing cases for guidance means we have to do careful case selection for when we go to the tribunal. And that's why I do again repeat my call to consider reverting to what we used to do in the first generation of cases, where there was an alternative pleading. Or let's bring more Section 418A cases to test how far we can go on the conduct that may well be a restrictive horizontal practice, but also may be completely benign. And that's why the regs that the Minister gazetted for comment, exempting SMEs, are so interesting. Because there's a recognition that collaboration matters in this economy, which is stagnant. And we need to also look at that policy context and framework. So I would make another final comment. I would love to see all of the passion of the Cartels Division directed at sorting out criminalization. Because criminalization hasn't been used yet because the way it's been drafted is a complete constitutional nightmare, right? That ability to correlate the constitutional provision that the NPA is the only prosecuting body and the way the criminalization provision is framed that seems to imagine the commission playing some role, it can totally be sorted out. Let's sort out criminalization and actually put someone behind bars like they do in the States. So rather than rejecting everything that came from the States, why don't we embrace that part? Because we haven't properly prosecuted any of these cartel members yet. So I would like to see a renewal. So Doris, since we're putting things on your to-do list uninvited, I would like to see the Commission re-engage with the NPA so that we can. I mean, we all have this frustration about where are the state capture prosecutions? What's going to happen with the Zondo Commission prosecutions? Are these people ever going to wear orange? I have the same question about cartel conduct. I have the same question about, Steinhoff. I have the same question about all sorts of other things. But, let's put someone behind bars for a cartel case. That gets you some more enforcement and, will continue to build on the Commission's track record for the last 25 years. Thanks, Marke.
Thank you. Mpumi is looking at me with her...
I have a proposal, though. I have a proposal, perhaps, because this panel is lit. And I think everyone wants to hear from this panel. This has been one of the most elucidating conversations on the topic, and we don't really want to stop. So the proposal is, lunch is ready, and those who want to filter out may do so, if we can just have some compromise about the noise outside, and we'll continue with this panel perhaps for another 20 minutes, if that's all right. I know that there's questions and answers. I wonder if there's members of the crowd who want to pose questions to the panelists. I don't want to deprive you of that chance. So you can make your own choice. Your blood sugar or people in orange?
Mpumi, I'm afraid that
10 minutes.
That is a sort of a Hobson's choice that you are giving the audience to choose between their stomachs or listening to the debate. Yes. We were about to do that. If we can just get indications of anybody who would like to Advocate My Nature Commissioner. I forgot your name. Yes, there's a hand over there.
Yeah, thanks. I'm not asking because I've been on opposite sides with Thembeka. I actually love being on opposite sides with him. But I just want to understand, maybe from Bill, and what Thembeka described as the statutory framework, analytical framework, whether in his understanding and perhaps Bill's understanding, what you're describing is not in substance the same as what ANZAC actually said must be done. In other words, you look at the statute and you determine the ambit of the prohibition, then you look at the conduct and you ask the question whether it is the kind of conduct which the section strikes. It strikes me that you are defining the same thing in terms of substance, but we are differing first in terms of terminology, but also perhaps criticizing how the KEK has applied the characterization test over time. So if the KEK was applying the ANZAC test properly, which is derived from the US, without naming it, in my view, substantively, it will be doing what you said is the correct analytical framework. And perhaps you and Bill and the others could reflect on that. I've had Michelle on the other side in Africa as well. So, thank you.
Bill?
I think that's a great question to move the discussion further. Although I'd like to know first, when do I get lunch? Is it going to be delivered? But secondary consideration. Maybe, how does this discussion go? I had a supervisor who once put developments in 3 baskets: the good, the bad, and the don't overreact. And I wonder if a way ahead in this discussion is to take Tembeke's last observation combined with our colleague's comment from the audience and ask, is the terminology we've been using here, and maybe is the terminology that's been used by the judicial tribunals, maybe ill suited to the problem we're trying to address? I think we would all agree that when you have a statute that has a set of prohibitions, there will always be a discussion about whether observed behavior fits within the prohibition. Whether we call that a threshold inquiry, whether we call it characterization, we have to decide whether the conditions for applying the law have been met. And maybe there are a host of questions we can identify clearly as being threshold issues of eligibility for prosecution. Plurality agreement, the plurality requirement of Section 4 satisfied. Is it a single enterprise or wholly owned subsidiary issue? That is, all of these questions of whether the essential conditions for the application of the statute have been satisfied. Maybe we have a different label to that. But then to put in another basket, the question about whether conduct that has ambiguous features. And let me mention what I mentioned by ambiguity. I'm not talking about those films from the licensing cart, which are useful for all of us to look at it. Here are the direct competitors sitting in a room talking about how they can reduce output and raise price. They are laughing at the enforcement authority. They do not have a good story to tell. The only question they were leaning on is what this agreement. They lost that decisively. So that's a clear scenario that we can put to one side. And as a footnote to that, I'd be worried if the further elaboration of the characterization jurisprudence casts a cloud over whether that's going to be forbidden. That I'd be worried about. I don't sense that that's happened yet. But I think the further question as part of our discussion, and maybe that's a workshop that the authority internally, maybe it's a fuller discussion that takes place with the larger community in the country, with the academic hubs in South Africa, with practitioners, to go through concrete scenarios. But the third, harder question is where there is a legitimate, plausible justification for the conduct. That is a justification that is true to the objective statute, where, to use my example involving collaboration of a number of small firms in order to bid, why would we put that in a different basket? In a sense, by agreeing to bid together, they've implicitly decided we're not going to bid individually, but individually would be futile. And let's even further imagine that they told the procurement authority this is what we're doing. Have they revealed the potentially suspicious conduct to the purchaser? Or have they kept it preserved it covertly? But I think to think about structuring the conversation so that we properly identify the threshold questions, and I like the way Tembeke has identified that. We identify those as a distinct set of questions, but then we isolate the larger and harder issue about whether the behavior in question has positive attributes, whether it is worthy of full inquiry, because the restriction we have observed serves a valuable pro-consumer, pro-citizen economic purpose as well, and how we go about testing now. But I think, again, if I look at the jurisprudence outside of South Africa, if we look at the bottle called characterization, there's a warning label on the back that spells out how you apply it and how careful you have to be about what kinds of arguments you accept as being a basis for fuller inquiry.
Thanks, Bill. I thought the answer would be brief. That's why I was taking this. Tembi?
Bill is never brief.
I misunderstood. I thought not 5 minutes, but 50 minutes.
He's delaying our lunch. I just maybe a comment and the question is going to be very quick.
Oh yes, we understand.
Yes. All right.
I disagree completely.
Yeah, we can sort it. I think the question, it's an interesting debate, right, on the approach to the law. I just want to say that it's got huge implications for investigation. So I understand exactly what Michelle, you're suggesting, the alternative pleading. But actually, once you get into that, you have to do this deep effects analysis, and that means investments in economy. So it seems to me that with your approach, you have to concede at least that what it means is fewer cartels, because, you know, enforcement cases we have experience. We know that you can only take a few of those, and it's understandable why you would take a few of those. It's impossible to finish them quickly. It's also impossible not to spend a lot of money on them. You're always going to do that. So I'm saying that it's an investigation question. And with respect also, it's not correct to say that we do this all the time in measures. We get over 400 measures a year. The economic analysis is probably one page, right? In 85% of those cases, 90% of those cases. The real cases where we do a proper deep effects analysis constitutes, I can tell you, less than 5% of those cases. In fact, those tend to be the measures that gets to be prohibited. And if you look at our prohibition record, it's very, very low. So what it means is that it's a question Eleanor has raised before, is how much resources do you want to put in a developing country competition agency to do this complex analysis, which, by the way, Europe says is not necessary. You know, so that's the trade-off. It's not about whether it's wrong or right. It's about where is the policy, you know, because it's about resources. You know, how much do you want to invest in this deep analysis? And of course, accepting that, then you are going to have less enforcement, even if you make that choice that you are going to do that effects analysis. But that's a question. That's a comment. The question is, on criminalization, what are you suggesting needs to be done?
Sure. And I'm going to take 1 second. So I absolutely accept that the Commission would have to make a new resource allocation, right? It would have to prioritize and identify cases that are worth putting the additional time and energy into to do what a 4.1b would require. My proposal there would be to say, okay, so let's identify categories of conduct that are these marginal questions. So it might be looking at joint ventures, it might be looking at restraint clauses, it might be looking at, I can't think of another example, but sort of drawing from the case law. And you sort of go, okay, this is a common commercial practice, relatively common commercial practice, so a test case on that type of conduct would be useful precedent to enrich and deepen the precedent that we've got on cartel conduct. So yes, it would require the Commission to do an exercise of identifying a case that looks as if it might unlock a typology of that kind of conduct on a range of sectors in the economy, and let's test it and let's do that work and identify a good set of facts for a good 418A test case that could then, and I do think that enhances, deepens, strengthens cartel enforcement, because you start expanding the range of prohibited practices away from the hardcore that we all understand and comprehend and come rushing off to the Commission on a leniency application for. So you would start expanding the terrain for cartel conduct if you picked good cases for common commercial features that the Commission is concerned about. But I accept that it means a lot more work has to be done. On criminalization, I think the Act probably needs to be amended again, right? The criminalization provision needs to be addressed because the way that it's currently framed raises all these constitutional problems about whether you're undermining the NPA's independence as the sole prosecuting authority according to the Constitution. And then regulating that framework around the if you cooperate in a cartel case, the Commission will argue for sort of mitigation, will argue for some kind of leniency in your criminal process. Those are procedural questions. Those are process questions. The NPA and the Commission can work those out. And it would take another legislative amendment to tailor that properly. And I don't know the detail, but my understanding is there is some kind of MOU or some working arrangement. You've had lots of engagements already with the NPA. I don't know what those are, obviously, but my point would be, let's operationalize something that's constitutionally compliant. Maybe it's a prosecutor seconded across to the Commission to do this work, same way people get seconded across to prosecute for SARS. Or specialist units that are now picking up the Zondo Commission recommendation cases. So there's a way to deploy NPA resources in companion with the skill and expertise of the cartels division at the Commission, and let's actually prosecute some people and put them in orange. Tembi, looking at you, I now see James Hodge is wearing an orange shirt, but that's just coincidence.
Yeah, there was a hand, Abraham. Next to Manda, there was a hand. Yes, yours will be the last one.
Thanks for a great discussion. In view of the sentiments expressed minus Michelle, I'm kind of curious to know, related to what the former Commissioner has just said about deploying resources wisely, what can we expect the Commission to do in going forward? Because it feels a little bit that you don't like the CAG decisions. And so I'm kind of thinking about when you look at facts and cases that fall squarely within Aranda, Tourvest, INJ, are you going to press ahead with a cartel angle in the hope of finding a different outcome? Or are you going to be influenced, albeit not liking those judgments, to say, okay, we know that if a relationship is primarily vertical, like the SAB case, the prism through which it should be looked at is vertical. So exclusive territoriality in a vertical relationship is not hardcore, and so you look at it through that and you look at the effects, versus if the premise of the relationship is horizontal, then we are looking at a market allocation case. What can we expect of the Commission going forward? Because it sounds like you just do not like where the world is right now.
I'm assuming that question is directed at Magale because you are looking at him.
Thank you, Chair. Two things. One, if we don't win the appeal at the Concord to correct these things, if the Concord doesn't want to hear us, because now initially they said there are no reasonable prospect of success. Now they are beginning to give reasons. There's some reasons that they provided when they were refusing us. access to leave to appeal. So if we don't win that, in fact, we don't get the leave to appeal and we win the case, so it means then the door is shut. Then we must make legislative reforms. We must change the law so that we are clear about this issue of characterization. And if we can't do that, then we must close down.
There is one. Yes, there's a question online, and then Eleanor. I'm just going to allow then Lebu, and then that's it.
This is a question from one of the online participants. Am I audible?
Your mic is not.
Thanks. This is a question from one of the online participants, and it's directed at Tembeka and Magale. It says, does it really matter whether the courts are inconsistent in which element of 4.1b must be characterized? Is it not ultimately about the nature of the conduct and its impact of the market? Are we concerned with maintaining commission wins, or are we concerned with maintaining effective markets?
Tembeka?
I mean, that question explains the problem. You know, that's precisely the problem, is that the asker of that question, whether it's a lawyer or what, I don't know, is concerned about impact. Right? That's exactly what we say is wrong. This is not an effects-based analysis. There are two problems with this. I mean, you've had, you know, my story for the last 3 years. I was sitting here with Dennis Davis. And I asked him, what is the statutory basis for it? And he says he couldn't find any, but it's there. You can't run this thing on the vibe of it. You've got to run it on the basis of a rigorous application of the Act. Now, so I think also Hamilton's point, you see, Hamilton, I think you're actually right about where do we go from here, is going back to a proper understanding of ANZAC. That actually ANZAC didn't say these things that have now started creeping into the jurisprudence. There are two other points from ANZAC, by the way, that are included in the jurisprudence but are not in ANZAC. One is ANZAC said some agreements, by their mere production, will be manifestly restrictive, and they will fall under 4.1b, under 1, 2, or 3. The law right now is that there is not a single agreement that on the face of it is an infringement. Second thing is, ANZAC said some agreements would have to go through a process of characterization, which includes economic analysis. The law right now is that each and every agreement must go through characterization. Each and every agreement must be subjected to economic analysis by economic experts, which is a vast departure from what ANZAC actually had in mind when it was drafted. And so that's why it matters that there is jurisprudential inconsistency, because it leads to less predictability. It makes it impossible for the Commission to know what are the allegations to be made, what kind of evidence should be led, because this thing is shifting all the time. So if we were then to go back to ANZAC, assuming that ANZAC is the standard, what exactly would we have to show? It seems, firstly, you would have to go through the threshold question, the statutory threshold questions of competitors' agreement, one of the three categories. The question is whether after that you have to do any other analysis. Your argument is you might have to do something more, which is the conduct of the nature that would, but that seems to be tautologous, because you've already undertaken it in identifying whether the agreement relates to one of the three items. But what characterization does is it asks two additional questions if you are characterizing the conduct as opposed to characterizing the relationship. It asks two additional questions. One is there a competitive restraint that's been removed by the agreement? Secondly, it's always blurring the line on effects. And that blurring of the line on effects sometimes takes the form of asking whether or not the agreement has any redeeming features. You see that in a case like Dawn. Two clauses in the agreement. One is your typical restraint, another is a non-compete. The Commission says once you have a typical restraint, the non-compete can only serve an illegitimate purpose. Then there is a full analysis that actually it can serve another legitimate purpose, and for that reason it's characterized as being non-collusive. Now, it's in that area where it's about the removal of competitive restraints, and secondly, about whether or not there are any benefits, efficiency benefits. But they won't call them efficiency benefits. But what they're trying to do is to find whether or not the agreement has any redeeming features. And that's where the blurring of the line has been. Because, I mean, sometimes when you listen to these economists speak, what they are doing is they're actually conducting an effects analysis under the guise of looking at whether the agreement has redeeming features or not. So it's those two that I've been arguing should be excluded from the analysis, either by the pure application of Section 4.1b as it is, or perhaps, as you, I think, are suggesting, and you are going to be my opponent soon if we get set down. But if what you've said is what you're going to say at the Constitutional Court, then you and I will be saying the same thing. Your client will probably lose and not like you. Yes. No, Hamilton is actually in a good position here because he is both for and against the Commission on the same point. So I don't know where his loyalties lie. Well, I know where his loyalties lie. His loyalties lie with the Commission. He is... he is literally sleeping with the Commission. So I think that if we are... So I think that if your point about ANZAC is that you can separate the statutory analysis and then introduce something else, I still want to push back on that, Hamilton, and say, what is this something else that you're going to put? Or you're not substituting?
You're doing the same thing. You're just calling it something different.
No, then we are completely together on that.
Professor Fox?
Thank you very much. So I wonder whether there is a missing middle that might be productive to think about, and this is it. That supposing that 4.1b is only for hardcore cartels, which would be pursued criminally, and there are other rather simple rules that you think, and it's right, that companies should not do, that would be civilly enforced, not criminally, and it would be developed under 4.1a. For example, and this is Karen and Beef and INJ, a rule that says you may not agree to discontinue manufacturing for Karen, and for INJ, you may not agree to never go. Let's see. Karen says it won't continue manufacturing, and maybe INJ says. Let's leave it there. So Karen says it may never agree with the distributor that I will not manufacture. So that kind of simple rule, which in the United States it gets into a quick look category, but it would be civilly enforced. And is there that opportunity to put these marginal cases that may not be hardcore criminal cases in that category?
So, Mr. Majenge, I'm so sorry to usurp you, but we do have a member of the panel who actually has to go. So I will allow, with your discretion, to determine which one panelist may respond to the comment. And then I must also apologize to Songezo because this is so much harder in real life. Thank you.
Michelle?
Last word. I think I agree with Eleanor's suggestion and, to the question about what to expect, nature of conduct, et cetera, I think, from where we started this panel to where we ended it, I think we know a couple of things. We know it's harder than it looks. We know it's going to take a lot of work. And we know that if we don't assume bad intentions, right? Santon mustn't assume the Commission's anti-business. Commission mustn't assume business is always colluding. Let's focus on getting the bad guys. And I think and then I would say the precedent is binding. So let's move on to some new and exciting topics and debates, and let's put Commission resources into those, including, once again, sorting out criminalization for cartellists. Thanks, Bake.
Yeah, thank you. Thank you very much. Can we please give a round of applause to our panelists? And to me. That's it. Thank you very much.
That was so well done. I must also apologize to Bill. I'm so sorry that I missed your virtual introduction on that one. We've got lunch now. And originally, I thought we were going to come back at 1:45. That leaves you 10 minutes. That's not possible. So what we're going to do is we're going to aim for 2 o'clock. I know that there's lines and the rest, but we'll keep you up to date. We've got digital after lunch. Please feel free to, continue the conversations through the break. Thank you all for being so engaged. This was fantastic.